My lord, I am mentioning one item number 46. In that matter, my lord, lordship passed an order 21/4/23, providing them liberty to make a mention to your lordships to upgrade the matter.
Okay, it will come up. These people will prepare it.
Yes, my lord.
All the matters pertaining to appraisal, instructions, these will all be listed at 2.
Wait, please, Your Honor. I beg to mention item number 39.
Yes.
When the matter has become infractious, I have been reinstated. I have an order matter that will be kept as a part of the record.
Listing.
Passing a long order in the motion help you. But Mr. N.J. Doctor, the learned counsel appearing on behalf of the petitioner, who submits that the petition has become infructuous in view of the order dated 25/2023, issued by the Director of Elementary Education, thereby reinstating the petition, taking into account the same. The said order is made a part of the instant record and marked with the letter X. According, the instant petition stands closed as it has become infructuous.
I am obliged.
Item 39.
May I, which I pray for listing of a repetition. The matter relates to pension. The matter was last posted on 20th of February of this year. So I pray for listing for admission column on 6th of June or 8th of June. That whistleblower matter, they have submitted that the pension papers have been submitted to the director.
Oh,
of
that
pension.
matter.
Yes, but till that matter, the petitioner is bedridden. On 6th of June, or 8th of June.
Why? Pension matters, does it require so much?
Lordship's conflict.
We'll have it out because I'm not here on 8 and 9.
Before that.
Not before that. Today is what?
Today is 31st of May, Lord.
We have it on 5th of June.
Lordship.
Lordship, I have a prayer in respect to item number 21, Lordship. With my friends, Lordship, I want to adjourn the matter for Lordship 1 week, Lordship. 1 week time is required in this case, Lordship. This case relates to Lordship, some Lordship employees whose date of birth has been recorded differently, Lordship. In different document, different date of birth has been recorded. In the regularization order, their date of birth is different, and in the service book, the date of birth recorded is different, Lordship. Now the department is Lordship has done the inquiry, and it is department is passing in notification is issued shortly, Lordship. I need 10 days or time, Lordship.
Mr. N. the learned counsel appearing on behalf of the irrigation department who submits. He requires an accommodation for 10 days for getting the instructions in the matter. Taking into account the same, let the matter be listed again on 21st of June.
Obliged.
May I please, Your Lordship? Your Lordship, I beg to mention item number 30, as we needed some more time to file our amendment to the prayer portion of the writ petition, Your Lordship. Your Lordship may kindly grant this.
Which one?
Item 30. 30.
You are appearing for?
The petitioners, Your Lordship.
The request of the writ petition of matter stands adjourned for 4 weeks.
My lord, I beg to mention item number 51, supplementary list, my lord. My lord, it may be updated, my lord, that may be taken as 2, my lord. That salary matter, my lord.
Which salary?
My lord.
Which salary?
Salary matter, the matter relates to salary, my lord.
What order was passed last time?
Last time, my lord,
Mr. Counsel, here all matters are pension, here all matters are salary, here all matters are transfer and suspension. So you saying this salary matter would not help you?
my lord,
Why?
maybe taken as two.
No. No abbreviation unnecessary. Yes,
May I please, your lordship, I beg to mention item number 2, the land council for the petitioner for his treatment is out of station
sorry,
regarding his knee surgery, lordship.
no adjournment on top of the list matter, sorry.
May I please, your lordship? Lordship, may I pray for item number 35 for upgrade the matter, lordship?
Why?
This is a suspension matter, lordship.
Okay, elaborate.
Develop, lordship.
May I please, your lordship, regarding item number 19, your lordship. On the last occasion, your lordship, there will the finance department and the elementary education department were given second time to file their affidavit without fail on 29/5/23. Your lordship, now they have neither filed it nor subject.
That is the trained, untrained teacher.
Yes, your lordship.
Okay. It will reach, don't worry. What do you want? Upgrading. It will reach,
No.
don't worry.
Supplemental is item 49 to be spoken to.
My lord, the charge sheet has been filed. Charge sheet has been filed.
My lord, I have the instruction. Charge sheet has been filed, my lord. I have the written instruction.
My lord,
In the
that
Borpeta case.
case arose out of when the petitioner was in my lord Karimganj as additional SP. An FIR was lodged by a person from Jonia in Borpeta district that using his particulars, 2 SIM cards were issued. That is telephone number 9707292394 and the other one was 9707292392.
Mr. Chaudhary, kindly see the affidavit filed by them.
Yes, in the
Read it. Now, there is a particular document that is document dated 5/10/2021 issued by the Superintendent of Police Borpeta.
yes.
Now, if you can kindly take up this affidavit, that is very relevant. Why I am asking you,
One second.
would you like to develop your argument on this?
Okay. Yes, paragraph, my lord.
Yes, kindly see Annexure A. Annexure A is the document on the basis of which the suspension order was passed.
1 second. Yes.
Annex-
Neeraj Verma.
This is the order by which the suspension order was passed because the reference of this order is
Yes.
there in the suspension order.
Yes,
Okay. Now down below, you see that is on the basis of a particular document
yes,
which was issued by the special superintendent of police.
yes,
Okay.
yes.
Now kindly come to the next page. This is Annexure B.
B.
Now Annexure B,
One second, my lord. B complete.
no, actually that is B. They have not
Oh.
marked it as B.
Oh,
Okay.
Ah.
Now that is Annexure B.
Forwarding
Now-
report of serious misconduct,
Absolutely. Now kindly see the date.
21/2/21.
Now this particular person bases his report on another report being submitted, which is at in the next page. Okay.
Yes,
Now there is no date mentioned
in
therein.
that, yes.
Okay. Now see who has signed it.
One Rahul Dhar.
No.
No. 1 second. It is signed by Jagdish Kumar Sinha,
So this,
Deputy Superintendent of Police.
okay. Now if you see the document which is at B
Yes,
is based upon that document which is being signed by this Jagdish Sinha.
huh.
Okay.
On 21/2/21.
So it has to be prior to that.
Yes,
Okay. Now this Jagdish Sinha, if you see, kindly see your charge sheet, which is at CID so and so.
huh.
There are 2 charge sheets. The
Yes.
first charge sheet is of the preliminary charge sheet on 18/12/2020.
Yes,
And the second charge sheet is the final charge sheet which has been given on 23/4/2021.
yes.
Now, this person has submitted this very charge sheet.
Huh.
And he gives a report on prior to 21/2 on a different thing.
Yes,
You see this? Now, because this is very interesting.
24, in April, he gives this.
No, this
20
charge sheet, final charge sheet
Ah.
is on 23/4/2021.
Yes, and
There's
then-
not a single whisper about the petitioner.
yes,
But the letter on the basis of which the Director General of Police asks for the purpose of suspension is based upon a letter of 21/2, which is based upon another information
letter.
report which have been submitted by this very person,
undated letter.
undated, where there is a specific reference wherein the petitioner is involved.
Yes,
Now, why there is no mention out here? That is one aspect. Now, kindly come to the document out there in your in this very affidavit, which is given out here.
yes, my lord. In this present case, my lord.
No, in the writ appeal, that affidavit which has,
Okay.
which you will. Kindly see, there is a document after that particular show cause notice, which was given.
Okay,
There's a
yes.
show cause notice out there.
Yes, my lord.
The show cause notice, there
24th
is
November.
24th of November. Then if you see the second page of the show cause notice,
Yes,
second page.
you should submit your.
No, thereafter,
Statement of allegation.
on top. What
why-
are the documents mentioned is the document of 5/10/2021 issued by the Superintendent of Police, Borpeta.
Borpeta.
Okay.
Hmm.
Now, if you see that document is enclosed down below, later on, the document is enclosed. Now, this document is the report being given on 5/10/2021. And if you kindly see that particular document, at 5/10/2000, it is not marked by any annexure, but it is a part of the document taking into account that this has been. Now, if you see the penultimate page of the said document, where the evidence of Saroj Sharma has been recorded.
Yes. Saroj Sharma, list of witness number 4, my lord.
Yes. Saroj Sharma's thing has been recorded. Down below, if you see. That would be page 24, if I'm not wrong.
Of the affidavit, my lord.
Yes, 24 or something, 21, yes, 24.
24, yes.
Yes, if you see,
He stated that he is the proprietor of Krishna Global Private Limited.
last 3 lines, last 4 lines.
Okay. As instructed by Rubul Hazarika, he handed over one bag loaded with rupees 40 lakhs to one person, Safna so-and-so, through Jitul Sandilla. At that time, he came to know from Rubul Hazarika that Rubul Hazarika and Nipu Pukon were at the police guest house of Karimganj along with SP Krishna and Prakhanda Datta.
Now, just before that last 4 lines, the SIM number.
Accordingly, as per discussion with Rubul Hazarika, he handed over the mobile handset along with SIM card to different persons, including Sanjit Krishna, the then SP, ASP Prakhanda Datta. The SIM number which was given to ASP Karimganj Datta was so and so.
This is the very number. Now you see thereafter.
As
Then he further says, as instructed by, he handed over the bag to so and so. At that time, he came to know from so and so that so and so were in demand along with the petitioner. Then, if you see the next thing which have been mentioned of Rubul Hazarika, he also categorically states that these are the persons concerned that the petitioner was involved. He was very much there. But these aspects were absolutely not there in the original charge.
Yes.
Okay. Now kindly see at serial number 6.
Yes.
IO also collected CDR of the mobile number so and so of Prasanta Kumar and found the same location on the date with effect from 26/8/22 so and so with location SIM card number so and so, which was also used by him.
Now, this entire period from 26/8/2020 to 29/2020, it has been mentioned out here that this was the very mobile which was there all along with you. This is with this allegation.
Yes.
So then I thought about it because this was not there.
But there is one very important thing. There is no call record emanating from this call to these people. Only thing what was registered was my phone number in the particular, my lord, a mobile tower.
No.
Yes, my lord.
No. Initially, I also
See, my
thought
lord,
like that.
IO also collected CDRs of mobile SIM
These are
card
the
number-
two your numbers.
My number, yes.
Okay.
Of Prokhanda Datta and found the same location on the date with effect from so and so with the location of so and so.
So-
That means my lord, location was same.
Not for one day.
Yes, for entire period.
Entire period.
Yes.
Therefore, they are assuming that this very mobile was given to you, which corroborates with what was the statement made by Soros. Now, this aspect, if you kindly see this very affidavit, your charge sheet,
Yes, my lord.
the first charge sheet.
First, sir.
I hate to repetition.
First, sheet, my lord. Page number 33.
Now, if you see, kindly come to your repetition, kindly come to page 144 of your repetition.
My lord. Yes,
13.1.
yes. The
Then you
list of
see-
documents enclosed in addition to earlier enclosed documents cited in the previous charge sheet, the following documents are enclosed.
Yeah.
One
Now,
original.
down below, if you see form CAF,
Yes, form CF provided by respective network service provider against mobile number used by accused persons enclosed at so and so.
so this is the very number which is there.
Yes.
Now, again, if you come out there, kindly come to page 149.
On top, my lord.
Yes.
In course of invest, details of newly purchased mobile handsets were collected from concerned vendor of Guwahati and the so and so source of the concerned mobile handset through mobile service provider. It was found that mobile numbers so and so were used in those newly procured mobile handsets and the same were used to carry out criminal activities of the instant case.
So there that number is there. Now again, come out here to page 152.
Yes, my lord.
No, not 152. I'll show you another aspect. Now, at this stage, if you look into another aspect which is there, would be this mobile number was never seized,
No,
as could be seen.
no,
Because all the seizure, neither anything was seized.
yes.
Now, do you have the charge sheet, the latest one? No, the latest one.
No, my lord.
Okay. Take on there. What is that? Give it. This charge sheet was submitted on 30/10/2021.
Yes, my lord.
But Mr. Chaudhary, I'm a bit surprised.
Ah.
Why the affidavit which was filed by the respondent did not mention about the charge sheet? Neither the reply which you have filed on 27th of May 2022 does not mention about the charge sheet, although you are an accused.
Yes,
On the other hand, in your affidavit, in your reply, you have mentioned that you don't know anything. Whereas if you see the charge sheet, kindly come to the investigation part portion.
this Borpeta thing, my lord.
Yes.
The copy has not been given to me till that officially, my lord.
Okay, but kindly see this particular thing
In fact,
because
I had appeared once also in the court below.
yes,
Record.
kindly come down to investigation portion.
Yes, my lord. Investigation.
Down below,
Uh,
the last paragraph. On the other hand,
On the other hand, from analysis of collected CDR, it is found that pertaining to movement between Karimganj and Guwahati, mobile number was in the same cell ID tower location with mobile numbers of suspected so-and-so. And it shows involvement of so-and-so in the instant case. Considering the fact and circumstances, notice was issued to so-and-so to appear before the court, so-and-so, on so-and-so suspected accused appeared before me. Yes, I appeared on that.
then Swarasi.
And recorded his statement under 161 CRPC. During the course of interrogation, Prasanta Doctor reveals that accused Rubul Hazarika were well known to him since his posting as Deputy Superintendent Headquarters, Moingao District. On the other hand, he also reveals that he met Rubul Hazarika at Police Guest House, Karimganj. Rubul Hazarika had a long discussion with the then SP Karimganj. Rubul Hazarika visited Karimganj and stayed at Police Guest House, Karimganj several times. He stated that Kumar Sanjeev Krishna, the then SP, provided hospitality to Rubul Hazarika. On 18/9/2000, he met Rubul Hazarika in Government Bungalow of Sanjeev Krishna. While Sanjeev Krishna opened the sealed packet of question paper of so-and-so, he also took a photo of the screen, but after a while, as scolded by Sanjeev Krishna, he deleted the photo from the mobile phone. Later on, he destroyed the mobile handset along with the SIM card. This is to be noted that Kumar Sanjeev Krishna opened the sealed packet of the question paper in front of him and he took photograph it later on. He deleted the photograph and destroyed the phone handset. On the other hand, Rubul Hazarika and Soros Sharma has described the entire episode of the crime committed by them along with Kumar Sanjeev Krishna, the then SP Karimganj, Prakhanda Datta ASP and the then additional SP Karimganj. The entire crime was committed at Karimganj district, but the criminal conspiracy started at Borpeta district. To the facts and circumstances of the crime of collecting SIM cards committed in Borpeta and a crime under section so-and-so has been committed by the accused Rubul Hazarika so-and-so so-and-so. Considering the progress of investigation and date of investigation of the case, now I submit the charge sheet part against Rubul Hazarika so-and-so and number 3 is the petitioner.
So this is what he has stated,
Yes,
as has been stated.
yes.
Now, would it be your submission to the effect that look at this, the order of 17.6, it was based upon a material which, on the basis of which even the investigating officer did not submit a charge sheet. Would it be your submission to the effect that that order of 17.6 was therefore based on no materials and by subsequent orders applying Mohinder Singh Gill, you cannot better the order?
Yes. You are right. No, absolutely, why not? Now, my lord, end of the day, Lordship is taking note of this fact for the purpose of delivering the judgment in the suspension matter. Whether it will come in the way or whether how your Lordship deals with it. Now, without saying much, my humble submission is, my lord, this is only a charge sheet stage. So, my lord, neither Lordships will give much emphasis on this, nor Lordships will discard it for the purpose of passing an order in the collateral proceeding. So, my humble submission would be on that line.
No, because you see, there are two things. One is your initial state submission, which was there, that period of 3 months was over.
Yes.
And as such, Ajay Chaudhary applies that. Even otherwise also, the order of 17.6 was without any, was based upon extraneous or irrelevant consideration.
Yes.
And as such, it was a malice in law. So that will be a second leg of submission. Now, in the second leg, there are these documents which shows, but your submission therefore would be that this has come into light at a later stage.
Yes.
They may take a very well a decision, some other decision at a later stage,
Exactly,
but for the purpose of
And
this,
Lordship is examining in the context of 17.6 what materials they had on that day, or what materials were in possession of the authority before passing of 17.6. These are all materials which has come to light afterwards.
even the review which has been done more particularly on 9/12/2021.
Yes, the mechanical, my lord.
No,
Absolute mechanical.
there they make a reference to that Borpeta's letter.
Yes.
Your submission therefore would be that, be that as it may, these are subsequent events.
Yes.
Until that day, they had no knowledge. They all subsequent orders, they have never mentioned anything about the Borpeta case.
Based on the materials which are available before the appointing authority today or the disciplinary authority, if they take an action, that is something else. But Lordship is examining the matter from the perspective of what were the materials on before 17/6. On that day, going by the events, my lord, it shows there was no non-application of mine. There was no material to reach that satisfaction.
However, liberty will be there if
Yes,
they want
yes.
to take into that.
Yes, whatever in law as maybe action may be permissible in accordance with law, that they can always take, my lord.
But how do you, if I touch on the other aspect which I have inquired, that you cannot culminate these proceedings in view of such a delay. How do you take care of that situation if I give them again the liberty?
No, my humble submission would be, my lord, Lordships will indicate in the order if your Lordship reaches a conclusion that there are materials which enable the disciplinary authority to take an action in accordance with law. Even if your Lordship does not mention that, that is always open to them, my lord. Even if your Lordship does not give the liberty to the state, nothing prevents the state from taking an appropriate action, my lord.
No, but the problem arises is, once the Borpeta charge sheet comes in,
Yes,
there is a criminal proceedings, which
Yes.
was not there at that point of time.
yes,
Now with the criminal proceedings coming in,
yes,
they will have a power to exercise under 6(1)(c).
yes, yes.
Now, if I hold it, taking into account the other question which I have been putting to him, that how can you culminate the proceedings? And this court cannot even give a direction, because if you see that particular, because of you, this matter, a lot of suspension judgments I have looked into. And in fact, I dictated the judgment. Judgment is
No,
also
my lord,
over.
it is certainly not my submission, for the sake of a case, that the power which is otherwise, my lord, endowed with the disciplinary authority, that is always there, my lord. Merely because I am holding a brief, I will not make.
Now, if I go on the question of delay, that departmental proceedings cannot be culminated, wouldn't that touch upon them, the power under 6(1)(c)?
That I think Lordship will keep open. I think that will have an, my lord, some effect. That aspect, I'll respectfully submit, Lordship will keep that open. Very touchy issue, my lord. Now we are at a very delicate stage, having regard to the materials which has emerged now.
Yeah. Now, that is the problem. Otherwise I could have delivered the
I
judgment.
think best way to deal with the issue would be to, my lord, keep everything open.
Now, if I
Without
keep it
encroaching
open, no, then I have already recorded in my order, I put it in, he's asking him, it is already there, asking him, how do you take care of that situation? Wouldn't then they touch on the 6(1)(c)?
So, my lord, without encroaching upon the power of the disciplinary authority, by keeping everything open, Lordship can deal with the matter, my lord. That would be my humble submission. Something like, my lord, my learned friend has said, when enlarging somebody on bail, Lordship
No.
is enlarging him on in that case.
No,
It is otherwise not required in connection with other case or something like that.
No, there is one judgment of Justice N. Nageshwar Rao
Yes, my lord.
following the case of what you call Ajay Chaudhary, that is given on 2018-17 SCC, wherein also it was a case of a suspension of an police officer. There was a trial going on, he was arrested, everything. But the Supreme Court says that already 2 years have already gone by. And there is nothing on record to show that there will be a tempering. So we reinstate him to a non-sensitive post.
Non-sensitive post, because that option is always given by the Ajay Chaudhary's case, my lord. He can be transferred somewhere else where he cannot, my lord, yield any power to influence anybody. And now, my lord, the proceedings have advanced too much, my lord. The question of tempering or other aspects will not arise. Now it is at this stage of trial.
Another question is, can't you take the evidence by way of videography, video conference, which is normally done in all other aspects? Can't you take it?
That could be, my lord.
Well, I think this aspect was deliberated, I think finality, because when it comes to, my lord, producing an accused on for a remand order, that is something it was taken on a different context. But then evidence and all, my lord, I think that finality is not there, my lord. And then, my lord, question of cross-examination is also there.
That is there. But if it is done on the video conference, can't it be done? Because interestingly, your document does not show that. If you see your affidavit which you have filed it says the CID report with 43 pages.
My lord, if my lord comes to page number 19 of my affidavit,
Yes.
that statement of allegation, there we have, my lord, it's a part of the annexure only, my lord. My lord, I will just read the statement of allegation. That
You just tell me. I have learned it by heart. Tell me.
I could make it out, my lord.
Yeah.
The initially when my lord started the thing, my lord was aware of even the page numbers. I was really
know
taken
that.
aback, my lord.
No, there you have referred to that Borpeta PS case number. You have already referred there.
Referred there, my lord.
Yeah, that's okay. But the question is it possible to have it by way of a video conference? No, then what I can do is reinstate non-sensitive posts, giving them without touching on that, giving them the liberty to initiate proceedings if they are in a position to get it through video conferencing. If that is there, then you can very well do it, if it is possible. And because why this I am saying it, you say that if you see this particular charge sheet, interesting, it's very interesting why you may think of challenging this charge sheet or something, because I'm telling you why. Kindly come to page at serial number 3, where the petitioner is being accused, made accused, serial number 3. On top, no.
Copy of the affair.
No. Particulars of the accused persons. Page number 3. I guess. 1, 2, 3, 4. The 4th page. Yes.
For charge sheet, my lord.
Yeah, the charge sheet. No, not that charge sheet. The charge sheet I gave it to you.
Okay. Page 4, my lord.
Yes.
One, two. Yes. Particulars of accused.
Yes. Accused number 3. Prasanto
Prasanto
Datta.
Kumar Datta.
Then come down to serial number 17. Date of arrest.
Yes, 28/10/21.
Okay. Date of release, same date. That means the police have given it. But could the police have given it when the allegation is of 424, all these things? Mr. Dhar, is it possible?
That is Prasanto Kumar Datta.
That is the person. You have put him different name. No, this is the person.
No, my lord, there are two persons.
I know that. This is the very person you have said. You have mixed up somewhere. If you see at that page, you have said that him as Prasanto Kumar Datta and everything, but you see his father's name. It has been put as Purna Datta.
No.
That is his father's name.
Then, my lord.
Yeah, and everywhere also you have mentioned him as Prasanto Kumar Datta.
No, my lord, there was two.
Understood.
One was DIG and
The other one is the Hotel Bharga, who was also, who is implicated in the other CID.
Yes, my lord.
CIDPS case.
Yes, ma'am.
But this is another person.
Exactly, ma'am.
This is the petitioner.
Oh.
Now here you have arrested him on 28/10 because on 27 you asked him to come. He came. On 28 you have arrested, and on that day you have released him on bail. How could you have done under 420, 406 non-bailable sections? You could have done it. I don't understand.
I think he had, he procured.
No, no, in this case, there was no bail.
No bill, no?
That is no bail. So on that day, very much you have released him on bail. Now kindly come, Mr. Here to this another document. Now, how did the investigation start? As regard Borpeta PS case number 43 can be seen from that particular document which have been enclosed to his affidavit. They say that they had taken the permission from the district judge. That is in that document of 5/10/2021. And that document of 5/10, you read it, no?
Yes,
No, page 25 of the affidavit.
yes, madam. Page 25. That, my lord, 5/10/21.
Yes, 5/10/2020. This is very interesting why I'm saying. Page 24, if you come to serial number 4.
On the other hand,
Ah,
accused namely Saurabh Sharma, Rubul Hazarika have been interrogated and recorded their statement with this case under section 161 CRPC as order passed by the Honorable Court at District Jail of Goalpara, District Jail, Nagaon.
so it is on the basis of that this was collected. Now in his affidavit, if you see this particular document, kindly come to page number 11 of that same affidavit.
Yes,
Down below, enclosure report of CID containing 48 pages.
yes,
This is of 22nd of May.
yes,
Okay. Then enclose, kindly see at page number 12, it is also requested that a report of so-and-so, which is registered in that detail, may kindly be collected.
yes.
Enclose as stated above. So they have enclosing everything.
Hmm.
Now out here, this undated document
Hmm.
states about, contains the, if you see here,
Statement of Saurabh Sharma, Rubul Hazarika,
yes,
Sandil, Vishnu Saran Mondal, everybody,
absolutely.
but not the petitioner.
The petitioner is not there, but this is not a part of this affidavit.
No.
Why haven't you not enclosed those?
And it's supposed to be a confidential document.
Chalo. I just wanted to clarify this.
Yes. But the fact of the matter is, my lord, for the first time on 27/10, we got to know about this. That is how we appeared on 28 about the Borpeta case, my lord. That's why we could not mention about this in the earlier proceedings.
No, but Mr. Counsel, you have mentioned on 27th of May 2022, you don't know anything about that case. How could you? When you have appeared on 27/10/2021.
Correct. Well, I'm handing over the charge sheet, my lord.
No, you keep it. I have an extra copy. I knew it. Both of you may not have it. Nowadays, with this justice app and all these things, we can get anything. Now,
That app, my lord.
it's Staple Mind. Huh?
That app, my lord.
Yes, that was which was launched by the Chief Justice of India.
Yes.
So these apps really help you to get
Yes.
everything. Now we can get these things. Any of this. Like that day, I was taking up one matter. The lawyer didn't know anything about that case. He was saying about civil judge in Nagaon. Then I could find out everything from there that it was already transferred to some other court and then in some other district, and then the matter was pending in that stage.
Deep.
Hearing completed, judgment reserved. এখন ভালকে ৰাখিব দেই।
Item number 1.
Yes, Mr. Sharma.
Lordship, in this case,
What are you asking for?
Lordship, in this case, what happened, Lordship, I have been possessing a land since 1949,
Okay.
and I have been paid all the revenues to the government, Lordship. The land was, Lordship, in the year 1989. I have been allotted as a Miyadi Patta land, that is in page number 23, Lordship.
Page
23.
3. Okay.
Earlier, it was a Aksana Patta land, but subsequently, record has been corrected and land has been transferred to the Miyadi Patta land, Lordship. And when the allotment was made, Lordship, at that time, demarcation, proper demarcation was made by the authority. And subsequently, in the year 1998, Lordship, page number 25.
No, why before this court?
Lordship, during the time of Lordship, COVID pandemic, Lordship, at that time, all of a sudden, I have seen that, Lordship, some people entered into my premises, Lordship, and started, Lordship, cutting my trees and demolished the boundary wall, which has been constructed by the PWD between the land of the petitioner as well as, Lordship, Gilamara Sports Association. And that boundary wall was constructed, Lordship, after due demarcation on, Lordship, 29th April 2021, Lordship.
Then,
Lordship, all of a sudden, that entire boundary wall that has been constructed, which was newly constructed, Lordship, demolished, Lordship. After demolishing the, Lordship, boundary wall, they try to, Lordship, occupy the land of the petitioner, Lordship. By the, at that time, Lordship, there was
who occupied?
Lordship, entire work was done on the stand of the, Lordship, circle officer, Lordship.
Understood. Who has occupied?
Lordship, not occupied, Lordship, try to occupy, Lordship, and
They didn't occupy.
No, Lordship, they have used the excavator to digging, Lordship, there, Lordship.
Very well. Then what has happened till now?
Out of 4 bigha, Lordship, 1 bigha, Lordship, they have, Lordship, have been covered to construct a new boundary wall, Lordship.
They made another boundary wall.
Yes, Your Lordship, which was constructed by as per the demarcation made on 29 April 2021. Thereafter, they came to started demarcation and also to construct new boundary wall on 5/7/2021, Lordship, after 3 months, Lordship.
So you say that on 29th of April 2021,
Yes, Your Lordship.
that the boundary wall was constructed.
Yes, Lordship, on that date,
Who were the people who constructed?
Lordship, PWD department, Lordship.
The PWD was functioning properly in constructing at the time the COVID was running
I
high
do
and
not know,
low.
Lordship, that the work was carried out by them, Lordship.
Didn't the lockdown notification come on 16/4/2021?
I do not, Lordship, in the year 2021, Lordship, at that time, Lordship, there is some restrictions imposed, Lordship, that
Full-fledged restrictions were imposed from 16/4/2021. Anyways, tell me, now what has happened?
Now what happened, Lordship,
What do you want?
Lordship, since the demarcation has made by the authorities in the year 1989, thereafter, Lordship, in the year 1998.
How much is your land?
4 bigha, Lordship.
Okay, as per the patta.
Patta, Lordship.
The patta has been cancelled.
No, not concerned, Lordship.
Sri Lakshmi. Patta number is 110.
Yes, Your Lord. Tag number
Tag
6 bigha.
number is 461. Kali is Sari Biga.
Yes, Your Lord.
Okay. So this was done.
Yes, Your Lord.
So you have this patta.
Yes.
Now you want a proper demarcation.
Lordship, land has been properly demarcated, Lordship.
Now what do you want?
Only I want, Lordship.
They are possessing some more land.
the land which was handed over to me as per the demarcation. made
Mr.
in the-
Sharma, you are making it late. That is why Mr. Goswami, who is always normally very quiet, doesn't stand up, is also standing. Tell me. Yes, Mr. Goswami, enough. of
The land which I have been
Petitioner
occupying.
has
Lordship,
two
that-
plot of land, Lordship. One is DAG number 651 and another is DAG number 637, Lordship. And the demarcation has been made in the plot of land 647, that is 33 acres of land, that is handed over to the BWG for construction of sports complex, Lordship. That is the petitioner's plot of land, where categorically mentioned in our affidavit, Lordship. That is separate
So-
land, Lordship.
Is it the case of the petitioner that you have encroached upon his land?
No, 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 that is not true, Lordship.
I read in the mayor so and so, I read in the nature of a allow, not to allow any person or authority for constructing of a boundary wall or so and so. Was the boundary wall constructed?
Constructed, Lordship.
So it has already been done.
Yes, subsequently, Lordship, on 5th of July, that has been demolished, Lordship.
So that has been demolished. Now, as of now, are you in possession of your land or not?
Yes, Your Lordship.
So what remains?
Lordship, but the thing is that, Lordship, if the boundary wall will remain same on the boundary wall which was, Lordship, standing at the time after the demarcation made on 29th April 2021. If that demarcation is correct, then I have no issues, Lordship. But the thing is that after that, Lordship, boundary has been, Lordship, trying to occupy my land. That is
Who?
the problem. Lordship, Gilamara Sports Association on the Lordship, the demarcation has been made by the circle.
By Gilamara Sports Association, go and file a civil suit.
Lordship, I have no dispute with the Gilamara Sports
Then
Association.
who is trying to occupy?
I have only the problem is, Lordship, that the Subansiri Revenue Circle, Lordship, who has made the demarcation in the year 1998, thereafter 2015, thereafter 29 April 2021. Subsequently, Lordship, they have changed their demarcation and they have changed the boundary and try to Lordship, reduce my land from 4 bigger, Lordship. That is my case, Lordship.
So if you are reduced, go and file civil suits. Why are you making Gilamara Sports Association a party?
Lordship,
No
as
party.
per the direction of this honorable court.
Why?
Lordship, as per the direction of this honorable court, I have
You
been-
must be having some allegation against him.
no, Lordship, I have no allegation against him, Lordship.
Besides, the land of the petitioner in the southeastern part of the has been occupying by Gilamara Sports Association under the Sports Department of Assam. At paragraph 3, you have stated. What do you want at last? Let me see. Should not to disturb the peaceful possession of the petition. A writ in the nature of mandamus should not be issued directing not to allow any construction for boundary wall or other construction without the premise within the premises of the petition. A mandamus should not be issued directing the respondents not to harass the respondent number here during the pandemic. Pandemic is over. Even who has said. A writ in the nature of mandamus should not be issued directing respondent to give advance notice to the availor by giving opportunity. Why do you need advance notice? You want to vacate?
No, Lordship.
Yeah.
I-
Whatever comes under the moon, you are asking. Yes, what is the affidavit of the state, sir?
Lordship,
Who is this respondent number 3?
is Deputy Commissioner.
I am the deputy commissioner. So and so that with regards to the man has admitted, the opponent has admitted the same and begs to say that for record 4 acres of land covered by so and so. Of Gilamara half map under here is recorded in the name of Lokimi. That is the petitioner, and the land measuring 14 acres so and so of dark number so and so is recorded in the name of Lokimi. So you have 2 plots of land.
Yes,
Lordship, under the dark number.
Mr.
637,
Sharma,
Lordship,
you answer what am I saying? You are trying to make
that is a
confusion.
Lordship joint.
How many plots of land you are having? 2.
I have, Lordship, 1 plot under Lordship.
Do you
651
have 2 plots of,
individual land.
Mr. Sharma, kindly tell me, do you have 2 plots of land or not?
Yes, Your Lordship.
One is 4 bigger, the other is
14.
14 bighas.
Lordship, I have.
Other is 14 bighas.
Other-
Mr. Sharma, I am asking you
not
the
14 bigger,
question.
Lordship, 15 bigger.
Okay,
That's well, Lordship, as
15
per the
bigger.
record, Lordship.
Okay. Where is the record?
Yes, Your Lordship. This is.
Show me that record. No, no, no. Show me from here. Where is the record?
No, at that time, Lordship, that land is
So
not disputed.
you are
Lordship.
saying that 637 is not an issue.
Yes, Your Lordship.
Okay, then let us forget.
Yes,
That it is a fact that as per the official records, 33 acres of land covered by 647 in the name of Iman by the regular Iman, and dark number 651 and 3 is adjusted. 651 and 637 is adjusted to so and so. Now show me that document about 637. Yeah. Mr. Sharma, don't further confuse. Enough, I've got it. Varoni Ram Dohinya. This is 15 bighas of land. Yes, why have you written 14 bighas? 637 contains 15 bighas. Huh? But you have not been dispossessed from 637?
Lordship, since the 637.
Mr. Sharma,
Dispossessed, Lordship.
you are still in possession of 637?
Yes, your Lordship.
You are still in possession of 651?
Yes, your Lordship.
Okay. Mr. D. Sharma, the learned counsel appearing on behalf of the petitioner. Mr. N. Goswami appears on behalf of
3, 4, and 5 lots.
respondent number 3, 4, and 5. What about 1, 2, 5, 6?
1, 2.
Mr. R. Dhar appears for the respondent number 2. Mr. R. Babujari appears for respondent number 1. It is the case of the petitioner herein that the petitioner is the owner of 2 plots of land. That is number 1, 4 bighas, 0 katha, 0 lecha, covered by dark number 651 of periodic patta number 110 of Gilamara half map. What is this half map? Under Moza Gohai. Number 2, a plot of land measuring 15 bighas, covered by dark number 637 of patta number 59. Under Moza Gohai, lot number 3, village Ghilamora, 1/2 Khondo. Khondo is what? Part. Half part. Isn't it? Khondo is part. Map লিখেছি। Full stop. The instant petition was filed on the ground that on 5/7/2021, the respondent authorities had demolished the boundary wall constructed by the PWD building department between the boundary of the petitioner's land and the land of Ghilamara Sports Association, and were trying to evict the petitioner from her private land by cutting the trees, demolishing the other structures standing within the premises of the petitioner by using excavator. It is the further case of the petitioner that although such actions were resorted to on 5/7/2021, however, the petitioner still continues to retain possession of both the plats of land. You are in possession?
Yes, I'm in possession.
Still continues to be in possession of both the plots of land as above mentioned. However, out of apprehension that similar steps will be taken by the respondents, again, the instant writ petition was filed. It appears on record that this court by an order dated 8/7/2021 issued note directed maintenance of status quo in respect to the possession of the land of the petitioner to be maintained by the parties. On that very day, an objection was raised by the learned counsel appearing on behalf of the revenue that Ghilamara Sports Association Lakhimpur was not included as a party. It is under such circumstances. I'm sorry. I continue. And made a party. And this court directed the petitioner to file an application for impleading the Ghilamara Sports Association as a party to the instant proceedings. It is in consequence to the order dated 8/7/2008 that ISC number 1390/2021 was filed. Whereby the respondent number 5, 6 herein have been impleaded. It further appears from the records that from time to time the interim order which was passed by this court was extended. In the meantime, the Deputy Commissioner had filed an affidavit on 9th of June, 9th or 3rd? 3rd.
Yes.
On 18th of December, on 3rd of January 2022. In paragraph number 4 of the said affidavit, it was mentioned that as per the office records, land measuring 4 bighas 0 kotha 0 lesa covered by dag number 651 of periodic patta number 110 of Ghilamara half part under Moza Gohai is recorded in the name of the petitioner. Further to that, another plot of land measuring 14 bighas 0 kotha 0 lesa of dag number 637 of patta number 59 of Ghilamara half part under Gohai Moza was recorded in the name of the petitioner and 5 others. It was further mentioned that as per the official records, 33 bighas of land covered by DAG number 647 is recorded in the name of the respondent number 6 in the year 1981. And the DAG numbers 651 and 637 belonging to the petitioner is adjacent to the DAG number 647. It was further mentioned that there were various applications being filed by the respondent number 6 for demarcation of the land. And on the basis of a public meeting held under the chairmanship of the subdivisional officer civil Dhokwakhana, in a meeting dated 5/7/2021, it was this meeting held on 5/7/2021 was fixed for demarcation of the land belonging to the respondent number 6. And accordingly, on 5/7/2021, in presence of various officials, demarcation of the land owned by the petitioner in DAG number 637, area 14 bighas, and DAG number 651, area 4 bighas were done and found exact land of each DAG with official record, and land area mentioned in the office record of total 18 bighas in both DAGs, and in field total 18 bighas in both DAGs were found. It was further mentioned that the demarcation of DAG number of 647, area 33 bighas, was also done and found the exact area of DAG with the office record, and that is the land mentioned in the office record total 33 bighas. And in field, total 33 bighas were found, and the same were handed over to the PWD building official. It was further mentioned that DAG number 647 is totally separate DAG to the DAG petitioner's DAG, that is DAG number 637 and 651 respectively. In paragraph number 14 of the said affidavit, it was mentioned that that no eviction was done at the land belonging to the petitioner covered by DAG number 637 and 651. And in the demarcation process, land area of each DAG with official records and in field were found same, and whereas the demarcation was done in the greater interest of the public. The legal counsel for the petitioner further submitted during the course of the hearing what is this land record? Jamabandi, the Jamabandi of DAG number 637 or Patta number 59, and submitted that the land in DAG number 637 is 15 bighas. However, it is the specific case of the petitioner that the petitioner was not evicted during that said demarcation process. Considering the above, this court therefore.
Half part I have evicted.
Huh?
Half part evicted only because of this order of this honorable court to maintain status quo. Lordship, I have not been evicted. Half part they have already cut down mati trees and all the standing construction. Lordship.
Have you been evicted or not? If any part of your land?
Some part, Lordship, I have been evicted. Lordship.
Why you are saying not evicted?
Lordship, because they after the only they have cut the trees. After this order of this honorable court, they have not done anything there.
So that land is in your possession or not?
It is my possession.
So then when you are evicted, However, it is the case of the petitioner that although there were certain steps being taken to evict the part of the petitioner from a part of the land, but in view of the filing of the instant petition, the petitioner have not been is in possession of his of her entire land. Considering the above, this court, therefore, in view of the specific submissions as well as the affidavit, in view of the specific statements made in the pleadings as well as the submissions recorded during and the submissions of the learned counsels for the parties, this court is of the opinion that from the materials on record, as well as what has been admitted in the affidavit filed by the Deputy Commissioner, it is clear that the petitioner herein is the absolute owner of dark number 631, 651, and dark number, and a co-owner will, along with 5 others, in respect of dark number 637. Both are patta number 59.
One is 59, Lordship. The other is not, Lordship. Other is patta number 110. 651 is Lordship 110.
Is the absolute owner of dark number of the land in dark number 651 of patta number 110, and is a co-owner along with 5 others in respect of dark number 637 of patta number 59. Although in the affidavit in opposition, it has been mentioned that dark number 637 contains 14 bighas of land. However, during the hearing, the learned counsel placed on record a document which is the integrated which is the Jamabandi of dark number 637 of patta number 59, wherein it shows that the total land in the said dag is 15 bighas. Under such circumstances, this court therefore disposes of the instant petition with a direction to the respondent authorities not to disturb the possession of the petitioner without following the due process of law. Anything else?
Lordship, since the process has been followed and
What process has been followed? Can you say that to be a process?
Lordship, no. In the year 2015, Lordship, if your Lordship will find page number 27, Lordship, that demarcation of that land pertains to 647 that has been done officially, Lordship.
Let it be done. We are not concerned with 647. You should be concerned with 637 and 651.
Yes.
And therefore said that not to disturb you without following the due process.
I don't know.
A complicated tender matter won't take so much of time with the matter which you have done. Yes.
As submitted earlier, my lord, the authority has in fact decided not to proceed with the scheme.
Oh, this one.
May I please?
Yes. What? Timing? Why? What is your prayer? What is your prayer in your case?
I am not about.
Don't appear before this court. You know, when a person doesn't know anything about this court, I consider him that he is not there in the case. And when he is not there in the case means none appears for the petition. I hope you understand that. So don't say anything. Or should I put none appears for the petitioner?
I call my.
Should I put none appears for the petitioner or what? Yes, your name.
Yes, something. Yes,
Namtulil. Appears on behalf of the petitioner. Mr. B. Goswami, the learned additional advocate general, appears on behalf of petitioners.
Respondents.
Appears on petitioners.
First state respondent, one is private respondent.
1, 2, 4.
1, 2.
The instant writ petition was filed challenging
And I think on the NIT.
the tender process by which the work was allotted in favor of the respondent number 5.
My lord, before issuing the formal work order, my lord, they came before this honorable court.
Challenging the decision to allot the work order in favor of the respondent number 5. Although at that relevant point of time, the formal work order was not issued. This court, by an order dated 23/5/2023, taking into account the submissions of the learned additional advocate general to the effect that the tender which was issued was viable at that relevant point of time, and the Water Resource Department, in view of the pendency of the instant writ petition and the order dated 6/1, 6/1,
Six,
6010. Order dated 6/10/2021.
Yes.
Whereby the parties were directed to maintain status quo. Sought accommodation to take instructions as to whether the Water Resource Department would go ahead with the said tender, taking into account that he had instructions that the said tender, that this work in respect to the said tender in the meantime had become unviable. Accordingly, this court fixed the matter today. The learned additional advocate general today have produced an instruction dated 23/5/2023 issued to him by the Chief Engineer, Water Resource Department, wherein it has been mentioned that as the work work order could not be issued in view of the interim order passed by this court. And as reported by the additional chief engineer, Barak Valley, WR Zone, Silchar, that the scope of the work had changed due to change in the river configuration and the change of the rates. Therefore, the work intended to be executed from the earlier administrative approval could no longer be executed, for which the department wants to submit the proposal afresh as per the present river configuration and prevailing rates. Under such circumstances, it was further instructed to the learned additional advocate general that this court be informed that the department wishes for cancellation of the above tender so the proposal can be prepared afresh. The said instruction so placed is kept on record and marked with the letter X. Taking into the said submission, said instructions, and as the Water Resource Department do not find it viable to go ahead with the said tender, nothing remains in respect to the instant dispute, instant writ petition. Accordingly, the writ petition stands closed.
And the authority is at liberty to proceed, my lord.
The authority is at liberty to proceed with a fresh tender if so advised.
Three.
My name may be recorded on behalf of JUNM.
No. I've been recorded. Somebody, you also want a proxy. He also wants a proxy. No, this proxy business doesn't work. Yes. No need. We can put in non-appears. Would you like that? Let us put somebody's name. That's a young person. He can be happy showing his client. Then look here, I got this order. The state government had to withdraw because of my arguments. Yes, next.
The method of this case is regarding non-payment of contractual bill amount, my lord.
My lord, yesterday, my lord, I had received instruction, my lord, and the petitioner, my lord, his admitted amount is 75%. He have completed the work, my lord, and the admitted amount is 9,975,000, my lord. This is the instruction yesterday I had received.
So you are going to pay within 6 months?
My lord, this at present, my lord, the budget, the validity of administrative approval, my lord, that was expired, my lord. So next proposal, my lord, when the.
Therefore, I'm directing you to pay from 6. This is 9 lakhs. How much? Soil conservation has got a lot of money.
My lord, no, my lord. Yeah. My lord, only 75% he have completed.
So let him complete whatever maybe, whatever his dues. Take note of that, make verification and pay within 6 months. I think nothing more. What else? Mr.
P.K. Mujumdar,
P.K. Mujumdar, the learned counsel appearing on behalf of the petitioner, Ms.
R.S. Deori, my lord.
R.S. Deori appears on behalf of the Soil Conservation Department. That is the respondent numbers 1 to 5. The case of the petitioner herein is that pursuant to a notice inviting tender in the Water Resource Department
My lord,
under the scheme.
Soil Conservation Department.
This is written wrongly.
Wrongly.
You don't know head or tail about your case, Mr. Counsel. The pursuant to a tender in the Soil Conservation Department under the scheme Protective Afforestation Plantation at Gindia Pathar, bracket part 2, under SOPD-G during the year 2019-20. The petitioner being found eligible was issued a work order on 14/8/2019. Is it?
Yes.
Your work order date is what?
14/8/2019.
Is that Annexure 1?
Annexure 1, madam.
Okay. It is the case of the petitioner that the petitioner completed the said work. And the respondent number 4, by letter number 9 dated 28/7/2020, issued completion certificate to the petitioner. At this stage, it is relevant to take note of that the said completion certificate is enclosed as Annexure 2 to the petition, wherein it is seen that the percentage progress was shown as 80%. The petitioner claims on the basis thereof an amount of rupees 13,30,000 for which the petitioner submitted the bill, claims entitled to an amount of rupees 13,30,000 for which the petitioner submitted bills, but the respondents having not paid the bill, the petitioner therefore has approached this court seeking for a writ, thereby directing the respondent authorities to pay the due bills of the petitioner amounting to rupees 13,30,000. Ms. R.S. Devi, the learned counsel appearing on behalf of the Soil Conservation Department, submitted that she has received the parawise comments which have been placed before this court. It was mentioned in the said parawise comments that the time allotted for completion of the work was 45 days from the date of issue of the work order. Therefore, the work should have been completed by 30/9/2019, but the work was done up to 75% only, as per the completion report issued by the divisional officer, Dorong Soil Conservation, Annexure 2. Madam, why you are saying 75%?
My lord, as per instruction, my lord, that as per my lord PWD format, he has completed 75%, my lord. Work.
Because there, this is handwritten, na?
Yes, ma'am.
Anyway, 75. It was further stated that as per the 75% completion report, the bill value comes to rupees 9.975 lakhs. Accordingly, the divisional officer, Dorong Soil Conservation Division, Mongoldo, had submitted a proposal for release of the payment on 6/7/2022. But due to non-completion of 100% work due to shortage of budget provision during the financial year 2022-23, the proposal could not be processed. It was further mentioned that the payment can be done subject to revalidation of the administrative proposal. Further, it was mentioned that due to timely non-completion of the work, the remaining 25% of the project had been already foreclosed by the Soil Conservation Department. I keep this.
Yes, my lord.
A perusal of the annexures to the said parawise comments further shows the communication dated 6/7/2022, whereby the divisional officer, Dorong Soil Conservation Division, had requested the director of Soil Conservation Division for FOC demand and sealing of fund insofar as the petitioner is concerned to the extent of 9.975 lakhs. It further reveals Therefore, from the stand which has been taken by from the Soil Conservation Department, there is an admission to the effect that there is an entitlement of the petitioner to the amount of rupees 9.975 lakhs. However, on account of shortage of budget provision during the financial year 2022-23, the proposal could not be processed. It has also been mentioned that the payment can be done subject to revalidation of the said administrative approval. Next. Considering the above, this court therefore disposes of the incident petition with a direction upon the responding authorities to pay the amount of rupees 9.975 lakhs to the petitioner after making necessary verifications. As regards the petitioner's entitlement, the said exercise be completed, the said payment be made within a period of 6 months from the date the certified copy of the instant order is served upon the respondent number 3. The instructions so submitted by the learned counsel appearing on behalf of the respondent number 1 to 5 is kept on record and marked with the letter X. Yes.
There are two IAs also, Lordship, here, wherein the respondent number 2 to 5, your Lordship, they are the private respondents. They have sought two applications. One is for deleting the names of the official respondents for respondent number 6 to 12, and also they have filed one more IA for vacation of the stay order, Lordship.
My lord, there is an order from the division bench also, my lord. My lord, before my narration starts, what to be briefed properly, my lord. Your lordships kindly accommodate me for a one or 2 days, my lord. It's not a matter which was tied up before that bench. All of a sudden. Yes, ma'am. Just for disposal of 2 days, my lord. If it is taken up on Friday or maybe on Friday, I'll do it, my lord. Good day. Last line. There is an affidavit has been filed, my lord, that due to that order, interim order could not be carried. Here, please, your lordship. I filed an application for vacating the interim order.
Yes, Mr. Chaudhary, what is your case, basic case here?
Basically, my lord, I have got the due permission and all. Thereafter, actually, what had happened, my lord, based on a false sale deed, my lord, the respondent number 5 is taking the claim. My lord, even if we concede that the land is in my lord tribal belt and walk, my lord, still state government has power under section 162(3), my lord. State government can always do that, my lord.
For what?
Giving the second up.
You are saying about 165(3)?
No, my lord, 165(3) is the 160. 1 second, my lord. My lord, 162(4).
You have set up some industry.
Yes.
Then,
That's going on, my lord, from 2014.
now what do they want?
My lord, they say that, my lord, we have encroached upon their land and all.
Their land means you are appealing for whom?
For
I am
respondent
appealing
number
for
5.
respondent number 5, my lord, actually case is not there.
Okay.
So we have filed along with some tribal my lord people, file an application in chapter 10 categorically stated that in tribal belt and block, non-tribal people cannot transfer uses possess of that particular plot of land. Against that, a notice, deputy commissioner issued notice, and they have appeared before the court. As per direction of this honorable court, 90 days time has been given to dispose of the matter. Matter has been disposed of by the deputy commissioner. Then thereafter, they filed a petition before the Board of Revenue. That was dismissed, and that was categorically stated that some judgment.
Now, what did the deputy commissioner do?
My lord,
Eviction notice, my lord.
eviction notice.
Under 165(3).
Yes. Yes.
Under 165(3), the
Yes.
deputy commissioner has
Yes,
done
yes.
it.
Yes. Yes.
On the ground that this land belongs to the tribal belt,
Yes.
and he has no authority to be there.
Yes.
So that is the exercise of power they have done.
Yes, my lord.
Whereas all the sale transactions were done based on the permission given by the deputy commissioner itself.
Then,
My lord, I
Now,
was
what is the
referring.
deputy commissioner? You see, 165 contains, if I'm not wrong, there are first 3 provisions, 1, 2, and 3A.
Yes, 3A.
One comes in respect to lands where there is no permission at all,
Yes.
which is a government land, there is no
Unsettled
permission.
land.
Unsettled land. Number 2 is in respect to annual patta land.
Yes.
And number 3A is where the leaseholder have not given any permission.
Yes.
Isn't it?
Yes.
So under such circumstances, his claim is that he comes under 3A. You have been granted the permission.
Yes, we have been granted permission.
So leaseholder not giving the permission does not
That
arise.
doesn't make any difference.
So he could not have exercised the power under 165.
3.
That is your case.
And my lord, this was not appreciated by the Assam Board of Revenue.
my lord, may I submit, my lord?
Before that, my lord, please come to
Let my
162(4), my lord.
Okay, let us start with.
No, my lord, what I was thinking, if your lordship will kindly accommodate me for today and tomorrow, Friday, my lord will take up the matter. I'll come fully
Mr.
prepared, my lord.
Chaudhary. Okay, understand, but the thing is like this. If I give a bit liberty to you here, tomorrow the Articles 14 violation will be spread everywhere. So kindly
My lord, one thing
appreciate
is that,
this
my lord,
court's also anxiety on this.
No, no, correct, madam. I'm not disputing that.
Because everywhere in all these top of the list items have been
Actually,
specifically
my lord,
asked
this
to
is
be.
not a matter to have, anyway, actually, my lord, I understand the top of the list matters are those matters on different category. This is not in that category. This was not tied up before that bench, my lord.
No, this
That-
must have been.
No, my lord, it was not tied up.
No, it is not a question of FIDA.
Yes.
It is a question that there is no order after 8/10/2021.
Yes, it is not been listed.
That is the reason why.
Maybe, that could be the reason.
I
But
argued this
not the
matter, my
reason
lord, when my
normally
senior was
we
alive.
understand, my lord.
And today the matter has been listed.
For 162(4), my lord. State government may, in the like manner, direct the provisions of this chapter shall cease to apply to an area or provisions of area to which they have been applied under the provisions of subsection 1. So, my lord, this power vests to the state government. It's an industry, my lord, where lot many people are being employed. And plus, my lord, it's a case where we have a bona fide right to litigate. It's not that, my lord, we are encroaching upon government land or something. Yeah.
Now this sale has been made by whom?
Yes, my lord will kindly come to page number 158.
Yes. In favor of Kalyani proper.
Yes.
Kalyani promoters are who?
My lord, they are a vendor.
So this was sold in 2010.
Yes.
Was it done with the permission of the deputy
Yes,
commissioner?
my lord, yes.
Oh, there on top.
Sale
it
permission
there.
is at page 171.
Page 158 on top it shows KRS 176
Yes,
of
yes,
2010.
yes.
Then who are these? These Aran Marak, Williamson Sangma and Ravindra
And my
Sangma.
lord, Mukul S. Lamare is the director of our company.
No. How is are they connected with the respondent number 5?
No.
How is respondent number
My
5
lord,
coming?
respondent number 5 comes into the picture by virtue of page 209, my lord, and which is a fake false deed. 209. Kindly see, my lord.
Has been sold by whom?
This is, my lord, Kardam K. P. Says the respondent number 5. And it was sold by a mother of respondent number 5. And my lord, kindly see on top 18220. This is a false deed number, my lord.
Why do you say so?
Yes, I say so because of, my lord, page number 240. When we took certified copy of that sale deed, my lord, then from office we got this.
This one?
At page 240. Because when we saw that registration number, my number, deed number 18220, we applied for certified copy, and my lord, we got this deed. It is between one Vidyut Panging and one Sky Limit Enterprises. Entire case of the respondent number 5 rests on that deed, and which is a fake.
And have you challenged it?
My lord.
Have you challenged it?
No, my lord, since that deed does not even, my lord, emanate, therefore no right flows from that.
Understood, but is it in respect to your land?
Yes.
Don't you think that when a document is there, it is required? Because if you otherwise, it has, your predecessor had purchased it in the year 2010.
Yes.
And if this deed is there in existence, a fake deed, then isn't it required?
My lord, honestly speaking, my lord, I'm
Well,
not very
perhaps
well versed with the
what
facts.
document has
today
been
to assist
annexed
your-
by DEP is a false document. Our document I have annexed in 103, original deed, my lord.
103 of what?
Of our affidavit. They have produced false document, our document.
My
my
lord
lord.
may keep it as
That is
further
the-
for Friday. my lord.
No, no, just,
Today I'm not
Yes,
in a
my lord.
position to assist your lordship. my
no,
lord.
it's okay.
103.
Okay, let me pass some effective
Yes,
order.
yes,
No,
yes.
otherwise it doesn't look nice.
Basically, what we are saying
Of
is,
your
my lord,
affidavit, where is your affidavit?
Affidavit, my lord, it was filed on my lord.
Affidavit
5,
number for
10, 2021.
255,
Yes, my lord.
255. Let me go. Yeah, don't file it. Hit me.
That is the actual affidavit. What has been annexed, that is not correct. This false document. They produce it.
Okay, let us see.
103. Original.
This one.
Yes, ma'am. That is the actual deed.
Bottom key P. It has been sold by Kodam
K. Api, my lord.
Ardum. Ki Api.
mother of respondent number 5.
Other Western members.
By Steny D. Nicholas Roy. Al Nicholas Roy.
Yes, my lord.
And so Nicholas Roy. Now, who are these people? They have not sold it to their predecessor.
Actually, my lord, before going to that, my lord,
Now, this sale deed by which they get it is from Aran Marak, Williamson Sangma, and Robindra Sangma. And your sale deed is from some Nicholas Roy.
yes, my lord.
Then,
That is the correct, my lord.
no,
Nicholas
understood,
Roy.
but how
Because
do- but are these people the owner?
yes, my lord.
How do you say?
Because, my lord, your lordship kindly go to the definitely. Is the owners there, Nicholas Roy. Article is it.
Mr. Chaudhary, can you tell me one thing? When it is disputed as to whether you are the owner or he is the owner,
Basically, it is civil court will decide, my lord.
can the authority exercise 165?
Actually, my lord, fact
No.
is not that, my lord. They are
165
now
can be-
jumble the facts, many facts. Actually, an application was filed before the deputy commissioner stating that this is a tribal belt and block land and that cannot be whole uses possessed by the non-tribal people. That petition was heard as per direction of the honorable court. 90 days application has been heard and that was disposed of. Then they go to the board of revenue and board of revenue dismiss in limine stating that this particular plot of land is under tribal belt and block and there is a judgment of the division bench Poddut Bora because I have shown in one order that they're directed to list the matter along with that matter Poddut Bora is contrary to the order passed by the division bench. Then they are coming before this single bench, my lord. I could not appear due to some reason, my lord, at that time. What happened? My lord? An interim order has been passed. This interim order is contrary to the order passed by the division bench because Poddut Bora, this honorable court has said in Sonapur Circle, that particular land is also involved in that particular land. All the tribal belt and block non-tribal people has used their land, transfer possessor user, they should be evicted from that particular land. In the affidavit filed by the government also that categorically state, we could not execute the order because reason behind it, there is an interim order passed in this case. So this division bench of this honorable court has directed to list the matter along with Poddut Bora and fixed on 18 June.
But
I
this
have
matter-
given that order.
No, directing this matter to be listed with that.
Yes, my lord.
So
That
why-
order I have given, my lord.
Very good. Saves me.
Last line.
File of the year shall be listed along with the 2 PR. Very good. Yes. Mr. Chaudhary, you
I'm
escaped.
not aware of that order, my lord.
No, very good.
This is the-
Mr. K. Chaudhary, the Learned Senior Counsel, assisted by Mr. N. Bharali. Mr. NNB Chaudhary appears for the respondent number 5. You are appearing?
For R1.
Mr. Arbor Pujari appears for the respondent number 1, Revenue Department.
For 2, 3, and 4.
Who are you? Okay, he appears for respondent number 1. Arbor Pujari appears for respondent number 1. Mr. N. Goswami appears for respondent number 2, 3, and 4.
I appear for respondent number 10, net fee.
Respondent number
10.
10. Mr. So-and-so as Bora appears for respondent number 10. Huh? Who are you? Name. A. Upamanyu. Your name. A. Upamanyu appears on behalf of the respondent number 10. And
I
you?
appear for respondent number 8, if it is.
All of you give your list. Huh? It's a too long a list. So-and-so. Upon hearing the matter, the Learned Counsel for the respondent number 5 produced an order dated 25/5/2023 in PIL number 78/2012, passed by the division bench. It appears from the same said order that the division bench directed the said PIL to be listed on 23/6/2023 along with the file of WPC number 4901/2021, taking into account the said order dated 25/5/2023. It would not be proper on the ground of judicial discipline for this court to take up this matter. Accordingly, list the instant petition along with PIL number 78/2012 to be listed on 23/6/2023 before the division bench. Okay. You are asking for 1 day.
PL 78/12 is a case, my lord,
Yeah.
where, my lord, it pertains to a government land, my lord, illegal occupation. I don't know how this matter has been dragged there. Anyway, my lord, it will come back here again, my lord, on 23rd.
Hello, all tribal belt and block people, my lord, not apart from government land, other land also, my lord, they are directed to be evicted. Otherwise, they said, we will realize from the deputy commissioner the money lost by that tribal people also. That order is available, my lord. And if government has categorically said that order cannot be executed because there is an interim order passed by this honorable court. That is why this on the division bench has said.
Very well.
Item number 5.
Made people also. My lord, this matter pertains to, my lord, to a challenge we have made to a settlement order.
You have challenged what?
A settlement order
Passed
by the respondent authorities in favor of the private respondent number 3. Mostly he was the, my lord, the procedure which is prescribed under the Assam Fishery rule by not inviting a tender.
Set aside the impugn order dated issued by the respondent number 7.
On the ground,
So this order has been made in whose favor?
my lord, made in favor of the private respondent number 9, we have implemented in the current writ petition, my lord, relating to this settlement which was made without following the due process and without calling for any NIT, my lord. Without calling for any tender process. I was one of the prospective bidders, my lord. Petitioner
Shall place the relevant records in original where the impugn communication was issued, setting aside this.
Lordship, we have received earlier received record and returned back because the case was not listed, Lordship, and we have filed our affidavit, Lordship. We shall again call for record, Lordship, if necessary, Lordship. Earlier, Lordship, record was
Understood. Now this, you are challenging a particular order dated
order dated, my lord, may kindly come to page number. My lord, for 48 of my petition, my lord. 48.
Yeah, settlement of so and so.
Number 1 is 1/70 Professor Bill.
I am to inform you that in the interest of BTC, fishery revenue earning and as per agreement with you dated 18/8/2021. So and so settled to you for a period of 3 years from so and so to so and so at the rate of 7 lakhs per annum with an enhancement revenue of rupees 10%. Okay, so you have challenged this.
Yes, my lord. We are on a very limited
So
ground, my lord.
limited ground is no tender.
No tender. Why, my lord? I'm saying at page 48, if your lordship sees, there is memo number 2 under reference serial number 2. They have referred some memo number such and such dated 10th of June 2021. Even assuming that particular letter to be an NIT, my lord, what happened prior to this? The same fishery was settled and was cancelled by the department for some reason of non-payment of the revenue. Again, it was settled with another incumbent on ad hoc basis. Now, during this subsistence of that period, in respect of the temporary settlement, they say that they have called for tender. They have issued the NIT on 10/6/2021, and thereafter, my lord, without cancelling that temporary ad hoc settlement given by the same respondent, they have initiated and given and awarded this settlement in respect of the private respondent number 8, my lord. As a matter of proof, my lord, we have been able to collect few documents. If your lordship comes to page number 43, my lord.
Just 1 minute. What is this fishery name?
This is called, my
1/70.
1/70 is Professor Bill in the district of Koprajam.
Santosh Kumar Brahma. Who is he?
Santosh Kumar Brahma is the current private respondent whom I have included, my lord.
There is some tender papers here.
Yes, my lord. The affidavit which I could see today, my lord, the filed by my learned friend, it shows that they have floated tender. But the question that I have raised, my lord, pertaining to the fact at page 43, if my lord may kindly come to page 43, my lord, it's very interesting. At page 43, prior to the date of issuance of the tender, my lord. Now, according to them,
Date of issuance is on 10/6.
yes, my lord, 10/6 is the date. Now, lord, kindly see on 13th of July, what they did, they have cancelled the fishery operated by one called Devojit Brahma. Why, my lord? With reference to the subject cited above, I am to inform you that you already violate the terms and conditions of deed of agreement by letter dated such and such 6 July 2018 for 3 years and breach of trust and by non-payment of outstanding lease of amount of rupees 9,58,000 and some odd, my lord, only for settlement of surrender bill in Kokaja district. Hence, the settlement of surrender bill in Kokaja district has been cancelled and expired with effect from 6 July 2021. So you are directed to stop fishing at above mentioned bill or fishery, otherwise undersigned will be bound to take action. Now, after cancelling this, interestingly, my lord may come at page 46 again. Page 46, what they did, they made an ad hoc arrangement again. At page 46, my lord.
But Mr. Counsel,
My lord.
from 6th of July 2018
Yes, my lord.
to 6th of July 2021 shall be the period? 3 years.
Yes, my lord. Contemplating term, my lord. Correct, my lord. Absolutely.
So, is there any problem in issuing a tender prior to that for a period after 13th of August?
No, my lord. My query is little different, my lord, with all due respect, my lord. The tender which they allege to have floated, my lord, is dated 10th of June 2021. As per the impugned order at page 48.
Yes.
So my question is, my lord, when a settlement was subsisting.
How can it be subsisting?
Yes, of course, my lord, because this 13th July 2021 has been cancelled on the ground of non-payment, meaning thereby on.
No.
Yes,
If we look into page 43,
yes, my lord.
the agreement was for 3 years.
Yes, my lord.
6th of July 2018
to 3 years
to 6th of July 2021.
21.
So what is the problem in giving it after that? Is it your case that after that only the tender can be issued, not prior to that?
Yes, my lord.
Why?
Because they could not have then made an interim arrangement after cancelling this by again giving it to someone else. Had it been a case that they are genuinely pursuing for tender, they ought not to have given a new, my lord, person for the same bill for another few temporary period. That is why, my lord, if I may take my lords to page 46, my lord, may kindly see. After cancelling this person, what they did was again at page 46 on 19 July 2021, if your lordship sees. What they did, temporary look after of the Sareswar Min Mahal in the Kokrajhar district. With reference to the subject, I am directed you to look after Sareswar bill under Upsi development until further order. This is a private individual. Had it been a case of a government.
Understood. Can't it be given for this next till the whatever, what will happen to this period, interim period from 13th of July?
What prevented them from holding the NIT if it was issued on 10th of June 2021? Because from their records, only 3 persons have floated, I mean to say participated in the tender, my lord. We are a cooperative society as per the rule under 60% reserve.
Are you denying this particular document which was published in the newspaper?
This document again is strangely
On Hayani Rabhag on 22/6/2021. Are you denying this document?
my lord, this document, my lord, which was furnished
At page running page 67.
My lord, the NIT which was published, my lord.
NIT is of page 66.
Yes, my lord. Yes, my lord. This page 67 NIT is published in a local newspaper belonging to the BTAD area, my lord. So this is again another cause which arises. They are meant to publish to having wide circulation.
No, that's a different thing.
Of course, my lord.
That is on a different aspect.
Different aspect, correct, my lord.
That we go into Ram and Shyam.
Yes.
We are not on that. But this is not your point.
My lord. So we had the apprehension, my lord, that this was done behind our back. We could not participate because the NIT was also floated in a local newspaper, which was in their own language, which was published. We did not know about this. And having come across this temporary arrangement that they have made, my lord.
Who is this Sareswar Min Samavaya Samiti?
My lord, this is, we are the cooperative society, my lord.
Where are you established?
We are under the BTAD area, my lord.
Then BTAD, that is the newspaper where it is there in BTAD. You would have said in Guwahati, these people were there.
We are from the BTAD area.
Oh, enough, no case. Heard Mr. H. Puragohain, the learned counsel appearing on behalf. You don't require any quotes. Dispose it off. The learned counsel for the petitioner, Mr. N. Goswami, appears on behalf of the respondent number 1, 2, and 6. Mr. Ardhor appears for the respondent number 3. Ms. R.B. Bora?
Yes, Lord.
Appears on behalf of respondent number 4, 5, 7, and 8. The instant petition has been filed challenging the order dated, order bearing number JDF/BTC/29/2021-22/744-A dated 18/8/2021, issued by the respondent number 7 to the respondent number 9. The limited point on which the instant writ petition has been filed is that the notice inviting tender dated 10/6/2021 was nothing but an eyewash in order to allot the settlement to the respondent number 9. Inasmuch as it is the case of the petitioners that by the communication dated 13/7/2021, the in charge joint director cum CHD Fishery Department had cancelled the settlement for Soreshwar Bill Fishery in Kokrajhar district with the existing settlement holder on account of breach of trust by non-payment of outstanding lease amount of rupees 9,58,500. And thereupon, immediately on 19th of July 2021, one Basbari Ansalik Committee APSU was given a temporary settlement until further orders by the said official. It is therefore the case of the petitioner that when there was a temporary settlement given, when there was an existing settlement, there was no reason for issuance of a NIT on 10/6/2018. Further to that, by the communication dated 19th of July 2021, the said fishery in Cochin was temporarily handed over, was allowed to be run by one Basbab Ansalik Committee APSU. And as such, it is the submission of it is the case of the petitioner that the documents enclosed to the affidavit in opposition, that is the tender notice dated 10/6/2021, which was followed by an advertisement issued in a newspaper which has which is not widely circulated, violates the right of the petitioners under Article 14 and 19(1)(g) of the Constitution. On the basis of it is further seen on records that pursuant to the filing of the instant writ petition, that this court have not passed any interim orders. However, the settlement made in favor of the respondent number 9 was made subject to the outcome of the writ petition. It further appears on record that the respondent number 5, who is he?
My lord, the secretary to the BT area, to the Fishery Department. My lord.
Who is the Secretary of Fisheries Department, BTC, had filed an affidavit in opposition. the said affidavit in opposition, various documents were enclosed. Amongst the various documents is the document dated 17th of February 2021, issued by the Secretary, Boroland Territorial BTC, to the Joint Director cum CHD Fisheries Department, thereby directing the said official to invite tenders of various departmental fish seed farms and registered revenue fisheries. The fishery in question can be seen as serial number 8 of the said document. It further appears that on 10/6/2021, the Joint Director cum CHD Fisheries Department issued a detailed notice inviting tender of as many as 16 fisheries, of which the fishery in question appears as serial number 2. The same was followed by a publication being made on 22/6/2021 in a newspaper, in the vernacular newspaper, Hayani Rabab, naam sune, HAYENNIRADHAB, Radhab. It further appears that on 13th of August 2021, the Secretary BTC issued a communication to the Joint Director cum CHD Fisheries Department, whereby the BTC had accorded approval of 14 numbers of comparative statements for settlement of revenue bill fisheries under the BTC. It appears as serial number 2 of the said document that the fishery in question, in respect to the fishery in question, the respondent number 9 was the approved holder. The comparative statement amongst the 3 persons who have participated in the said bidding process was enclosed as Annexure 6 to the affidavit in opposition. It further appears that in pursuance thereto, the deed of agreement for leasing of the fishery was entered into on 18th of August 2021 between the respondent number, who is this Joint Director? What is the respondent?
My lord. My lord, respondent number 7. My lord.
7. Between the respondent number 7 and the respondent number 9. And on the same day, the impugned communication dated
18th August.
18th of August 2021, Annexure 8 to the petition was issued. Upon hearing the learned counsels for this court before further proceeding, Upon hearing the learned counsels for the parties and upon perusal of the materials on record, let this court take into consideration the contentions which have been made, or let this court analyze the contentions so raised by the petitioner. The first of such contentions which was raised was as regards the issuance of the tender on 10/6/2021 during the pendency of the settlement in respect to the said fishery, as well as when after the cancellation of the earlier tender settlement, fresh for a temporary period, another a committee in the name of Basbari Anchalik Committee was allowed to run the fishery. In the opinion of this court, taking into account the materials on record, as referred to herein above, that is the document dated 17th of February 2021, wherein permission was duly accorded by the Secretary of the BTC for going ahead with the tender process. And thereupon, the tender process having been initiated on 10/6/2021, and thereupon, and in consequence thereto, it was only on 18/8/2021 the settlement was awarded to the petition to the respondent number 9. This court does not find any reasons to interfere with the same, merely on the ground that the tender was issued during the pendency of the earlier settlement period. In fact, a perusal of page 43, a perusal of Annexure 6 to the writ petition, which is the trump card, which is the main document on which the petitioner's contention, the petitioner, which is the main document on which the petitioner raises its contention, also shows that the earlier settlement period was from 6th of July 2018 for a period of 3 years, and therefore the period would have ended otherwise also on 5th of July 2021. And as such, calling for a tender earlier, taking into account the administrative convenience, would not in any manner can be said to be, cannot be in any manner be said to be in violation of the provisions of Article 14 and 19 of the Constitution. The learned counsel appearing on behalf, the second contention so made by the learned counsel appearing on behalf of the petitioner, that the advertisement, that the paper notification which was issued in a newspaper which was not widely circulated. This court put a specific query upon the learned counsel for the petitioner as to whether the said newspaper is circulated in the area where the fishery is to be settled, advertised. The learned counsel with due fairness submits that the said newspaper is circulated in the BTAD area. This court, taking note of Annexure 2 of the writ petition, wherein it is said that the petitioner society is confined to BTAD area. This court does not find any justifiable reason to interfere with the said process to the said settlement so made on the ground alleged by the petition, on the contention so made by the learned counsel for the petition. Considering the above, this court does not find any ground for interference with by way of the instant petition for which the petition stands dismissed.
I'm deeply offended.
Deeply.
Now 50.
I'm appearing on behalf of Fishery. The brief has been taken back from.
Which one?
Item 50.
Also, there's a yesterday matter, Lordship.
This
that the
matter,
PNB
Mr.
was-
Arsina was appearing. Why you
Yes,
appearing now? I have asked him to take one instruction as to whether did he receive it or not. Tell.
I've been just informed the client that the brief.
Huh?
The client has taken back the brief from us yesterday. And today morning, Lordship, I've been informed that Mr. S. Sharma has been engaged in the matter. And he requested me to take an accommodation for the case.
So none appeals for the petitioner, will dismiss it for default. Matter ends. We'll take it up at 2. Ask whoever it is, whoever has taken, because you can't shirk your responsibility. And first of all, Mr. Nair is a senior counsel. We're not concerned with him. Other counsels, Mr. Arsina has to appear before this court and say, I've asked him a specific query on that. If he does not, dismiss it for default. None appears and vacate whatever. Any order?
Yes, Lordship, there's an interim order,
Oh,
Lordship.
my goodness. We'll take it up at 2. All the fellows. Today we are rising at 1 o'clock, getting used to tomorrow's thing.
Yes,
'21. 6th of June 21, it was refunded to his account.
This is refunded to the account on the basis of what provision of the NIT?
There are 4 participants. The two tenders were rejected. The amounts of both the tenders were refunded on 6th of June. The statement I have.
When was the work allotted? Five, 2021.
5621 is the minor decision by which the tender was cancelled.
And when did you allot?
Is the completed statement.
Come to get it. Come to get it.
Mr. Das, you are not aware.
And the status quo was issued on 11/6/21.
Understood, but are you not aware whether the work was allotted to you or you were found to be the successful bidder?
Workshop, in 2 minutes, workshop, I'll take that instruction. Just 1 minute.
Huh?
In 1 minute, I'll take the instruction. The work order has been issued or not.
No,
Otherwise,
the
I-
minutes of the bid
under the-
evaluation was held
On 5th June.
on 5/6.
5th June.
Okay, then when was the price bid open? You have the records. I've asked you to get the records.
Plus the records, both the, yes, Malad, I have both the tender papers online and hard copy of the petitioners are with me.
Give it to me.
Plus. Well, in the packet, we have given the hard copy and the online copy, we have taken print out.
This was online?
Online. Work order was perhaps not issued because there was a status code on 11/6.
If the work order was not issued, where is the question of returning the EMD? Kindly see page 50. No, Mr. Kindly see page 57.
Bidder shall submit with security. Bidder shall
16(6)(c).
C, my lord. With security of there shall be 15 days of the allotment of work and no claim for interest of civil. It is for the,
Without the issuance of a work order, how can you return?
it is for the unsuccessful bidder, my lord.
Understood, unsuccessful bidder.
The bid of the petitioner was found technically not responsible. In the technical, it was rejected. Malad, this is the statement I have, Malad. In fact, these things are. Nowadays, I think after this tenders are issued, my lord. Yes. I think at the moment it is technically not, I mean, cancelled. Responsive, I think the EMs are, my lord, returned. It is only in cases, my lord, where the work order is awarded, then the money is retained because that is adjusted against the bid security.
Understood, but then it is not at his volition this has happened.
No, my lord. No. What has happened is, when the money went to his account, then he should have refused. That he did not.
How can you refuse it when it goes into account?
Even thereafter, he could have said that the protest letter or something could have been given.
Understood, but then also here the bid security is only given, unsuccessful will be both, not only you can't say that, and unsuccessful will be also a technical person also.
No, my lord.
Technical or price
bid. Because, my lord, his bid was not attested. It was on that count, the bid was.
That is another aspect.
That is on the merits of the case.
Yes, but for the fact that the petitioner is not otherwise has no locus because of his being returned would not be proper in view of 16C.
No, my lord, according to me, my lord, subject to what your lordship may say, when in the online system, when the money came to his account, my lord, over that he has no control. I'm not saying that. But thereafter, he must have realized that money is a company. He must have written some letter saying, I'm still in the contention. I'm not accepting this. That he did not do, man. I'm on that, man. In this system, it would automatically goes back.
Now this particular document, this document which is the hard copy, everywhere it is attested.
In the hard copy, lordship.
What about the other copy?
In the online copy, lordship will find the pages are folded. Those documents are, in fact, the number of documents are also in the online. It is no, the pages are more, and those documents are not attested.
Which are the documents which are not attested?
Those are folded. Half folded.
My lord, what is required to be, made copies of the hard copy with attestation?
Yeah, exactly.
So they should have scanned the, my lord, copy after attestation, and one hard copy they will give it to the chief engineer office.
In fact, page 55 of the petition tender clauses, my lord, it provides.
So these copies which are folded is not a part of the hard copy.
No.
Now, whether these documents are necessary to be given in the hard copy?
Yes.
Yes.
The hard copy and the online copy, that should be same. Otherwise, how do
maybe. But just for example, if you have given in the online some unnecessary things which is otherwise not required.
So those are, if lordship kindly takes up the documents, my lord, those are.
No, just for example, this particular document, the PAN card.
Lordship.
The PAN card does not have a attestation. This attestation, there is a signature of somebody. Whose attestation is that? With a round one? You have a copy of this? No.
No.
No. This round one, whose signature is this?
Even
Koilen Kumar Sharma. Who is this? Oh.
Soilen Sharma is the petitioner.
So his signature is here.
No, attestation kindly see, my lord, he has given in a different formula. But kindly see the registration are RC documents of the vehicles he is having. Those he have given, my lord, and along with other documents. Those are wider documents for the tender. He has not attested.
These are assessment years. Assessment year. This is what document. This is in traces will be form 26A. 26AS. This is the TDS documents. Now, whether it is necessary to enclose the TDS documents?
Well, if those are not necessary online, whatever document he has submitted online, he should give us the hard copy. Otherwise, there is some discrepancy. Otherwise,
that is a different, Mr. Nath. That is not what I am saying. My thing is, just for example, a person, is it your anywhere mentioned out there?
Yes.
That if the documents which are there in the physical copy and the online copy, bit copy has to be one and the same?
Logic.
No, you don't say all. To me.
Will kindly come to page 58 of the writ petition.
Page
58. Submission of bids. May I read it?
Yeah. Only bids.
Online bids will be accepted. Both technical and financial bids will have to be uploaded through online. However, one hard copy of the technical bid supporting document self-attested of the ITB is to be submitted in the office of the chief engineer so-and-so. For verification and checking authenticity of the documents during evaluation. A. Technical bid with scanned copies of bid security, cost of document and other supporting documents as per ITB. The scanned copy need to be in color PDF format and only an original documents need to be scanned only.
So here the attestation is not required.
It is there, my lord. The bidder should invariably submit index so-and-so, so-and-so, so-and-so. Kindly come to B, my lord. one hard copy of the technical bid, supporting document only self-attested of
That is-
ITB
no,
is
no.
to be submitted in the office of the so-and-so for verification, checking and authenticity.
Understood, but that is offline.
Offline, yes,
Offline means by hand.
yes.
That is not online. Online, this is here the basic case is that the online did not have the attestation.
The page 55.
No, no, Asha, it is there. my lord.
Page 55.
Yes, page 56.
55.
Five what was, huh?
Note, madam. Two, note two, photostat
Wait,
copies.
page 55.
Page
Yes.
55, note two. Photostat copies, scan copies.
Duly attested by the contractor are to be submitted.
Okay, but does it say about these are photostat copies, scan copies?
Yes.
Duly attested by the year are to be submitted, but it doesn't say about the online mode. It has to be attested.
No, my
Madam,
lord,
in the-
no, 56. Kindly come to page 56, my lord.
Scan copies are submitted online only.
The bidder shall prepare technical bid, one for submission to online.
Mr. Nath, is this not a scan copy? It is a scan copy.
This is scan copy.
You have given it by hand also. You have taken out the printout.
Yes.
You see, any document has to be, there might be a scan copy also.
My lord, there is a
In the
requirement
hard
of self-attestation, my lord,
Yes,
page
yes.
56. The bidder shall prepare a technical bid, one for submission to online and another hard copy for manual submission at the office of chief engineer within the last date. The information, particulars, data required for technical bid should invariably be filled up as per prescribed format on all pages, including supporting documents must be marked with self-attestation, including a hard copy of the technical document need to be submitted with self-attestation in case of a hard copy submission only, and in case of soft copy so-and-so, need to follow the instructions mentioned above under clause
So
of
there
special
again,
information.
in attestation in the case of hard copy submission.
My lord, no, both it says, my lord.
No. Then it says, and in case of soft copy mode, the bidder need to follow.
No, kindly see, my lord. Information, second sentence, particulars, data required for the technical bid should invariably be filled up as per the prescribed format. And all pages, including supporting documents, must be marked with self-attestation, including a hard copy of the technical document need to be submitted with self-attestation in case of a hard copy. That means, my lord, after including, that is regarding hard copy submission.
Hard copy attestation.
Prior to that, my lord, must be marked with self-attestation, including a hard copy of technical document need to be submitted with self-attestation.
Understood.
Yes.
Self-attestation, it is
In case of
including a hard copy of the technical need to be submitted with self-attestation in case of a hard copy submission only. So you see, and in case, then it says, of a soft copy online mode, the bidder need to follow the instructions mentioned above in the special
My lord,
information.
I am visualizing a situation, my lord. What I will scan, my lord? The hard copy which I have given, one hard copy I have given in the hard copy form. Another I'll put it on the online. Can we visualize a situation, my lord? Hard copy will be attested and the scan copy which is made from the hard copy is not attested. That means what he has done, my lord, he has initially uploaded his bid without attestation. Then following post attestation, he has given his hard copy. That is, he has done. My lord, in the ordinary circumstance, we cannot visualize a situation. What will be scanned? What is the hard copy? So invariably it must contain the attestation. It's not that, my lord, for the purpose of online submission, he will not do the attestation, and for the hard copy they will do. Normally, once it is ready, my lord, scan copy will go online, hard copy will go in the offline. So that is what has happened in this case, my lord.
How do you submit the online?
And secondly, my lord, there is a difference of pages. When the earlier on one or two occasions the matter was listed, when government produced the record, it's so transparent, my lord. In one of the order of the learned single judge, this is noted also. There is a lot of difference between the two submissions. One the hard copy, other the online.
There it is there. A lot of other pages are there. There's no quarrel with that. That is why I asked him as to whether these documents are essential, which have been submitted by online. and not being submitted in the physical mode.
My lord, my humble submission would be, my lord, the best way to attain transparency in these matters, as His Honorable Supreme Court says in that West Bengal versus Patel engineering case, is to follow the tender norms, my lord. Tender norm says it must be attested. They have not given. That's the only point.
But how do you take care of the word only and in case?
My lord, there are some in the language, but my lord, what I was trying to emphasize on is with self-attestation. No, the previous sentence, my lord.
And this, if you read it will later on with
my
that
lord,
particular submission of it.
I agree with your lordship.
Kindly come to page 58, because there it says online, if you have to do, it has to follow as per the submission of bid, which is given at clause 18.
Special thing.
Yes.
Yes.
At clause 18.
Now, clause 18, my lord, no, if your lordship kindly comes to, my lord, first, my lord will kindly come to page 55. The note in my humble submission is important, my lord. Photocopies, scan copies duly attested by the contractors are to be submitted. So, my lord, if the bid is to be accompanied by any document, then it has to be attested. So that's a general thing, my lord. So if we read the whole clauses, my lord, harmoniously, then, my lord, attestation is a requirement.
So if we do send the original, is it required to be attested?
No, my lord. Original, naturally, no. Supposing, my lord, I have a PAN card. I'll not give the original PAN card. I'll get a Xerox copy. So that.
No, wouldn't that the Information Technology Act will come in? Because the moment you are uploading a particular document,
yes,
wouldn't the original will take effect when you are uploading it?
My lord, that context, I'm not in a position to answer the straight away, my lord. But what I could see is the documents which will be uploaded, it has to be attested. It's not, it will bear the signature of the bidder. Just he will authenticate, he will take responsibility for that. There is a purpose, my lord. Tomorrow, supposing a false information.
No, why I'm saying, let you explain. We are in the process of having e-certified copies. Or any document nowadays, you see a government producing a document e-sign. That document, technically, if you see, has no value.
Because it doesn't contain any signature and nothing.
No. The moment it is taken out.
Okay.
It has the value till it is there in the computer. The moment it is out, you require a signature and an attestation. That is the reason when I'm asking you.
Lordship can import the same meaning here also. Supposing in the bid, he vouches through a particular document. It so turns out that that's a wrong document. Then if this signature attestation is there, then we can bound him. He will be bound by the thing. We may take some action.
Absolutely. So in the hard copy, it is required to attest. Just for example, a scan copy. You are taking a scan copy of something.
If
you
it is,
need to attest it. Yes, it is the original photo state.
If it is computer generated, yes.
You have to attest it.
Yes.
When you are giving the hard
computer
copy.
generated, yes.
But if it is there in the computer, on the by dint of the Information of Technology Act, it will take over.
No, my lord, here is a simple case, my lord. If you read the different clauses, yes, my lord. In some of the clauses, the language is not very conducive in the sense, my lord. Two meanings can be, my lord, called out. But if we read it as a whole, for example, my lord, this note, photostat copies, scanned copies duly attested by the contractor are to be submitted. So is it so unintelligible that a contractor can feign ignorance that, no, sorry, I couldn't get out of it?
Because you see, the attestation which is being made in an online copy cannot have any signature, has no value. It has to be digitally signed. That is the reason why it is not given. Now, therefore, the question is, as I was saying about the e-certified copy, it cannot have a signature of ours out there or the person that this is the year. It has to be on the basis of a digital signature. Therefore, you don't require an attestation for the online.
No, in the context, lordship is indicating yes. But in the context of the tender requirement, it has got the other purpose to achieve. Therefore, my lord, is necessary. In my humble submission, my lord. Then let us read it the scheme. Then page 56. The bidder shall prepare technical bid, one for
No,
submission
Mr.
to.
Chaudhary, why don't you do one thing?
Yes.
Just satisfy me only one.
Yes.
There are few documents which he has shown it, which were not a part of the physical.
Okay.
Whether these documents are necessary.
Clause 17.
If it is necessary,
then
why should I interfere?
Yes. No, if those documents are necessary to establish his if those documents are necessary to establish his credential, certainly it is.
That is why. Then whether the decision has been wrongly taken or not,
Yes.
why should I?
Yes.
Under 220.
No, Lordship is correct.
Instead of going into this.
And naturally, my lord, when he has annexed certain document, he hasn't annexed just for the sake of it, my lord. He's trying to establish something out of that.
That is there, but only that is why you need to show me that you see what is required out here. You see.
That, my lord, because the records we have not accessed.
No, that is why let us see these documents. Technical bid, what are required. Affidavit of bid, affidavit of work, financially soundness, so and so, valid up to date registration in the water resource department. Now these documents are what which have not been given. This is a licensing authority, labor commissioner. License to be granted to so and so under section 21(8). Is that required as per this?
I think the labor license is required, my lord.
Up to date license, individual certified for Iman. Now, this document, is this a document part of the hard copy?
So whatever documents are not in the hard copy.
It is there. Why have you done that?
No, that is in folded. Some
The
documents are
folded
there.
document is there.
Kindly see 17.1, clause 17.1, page 57.
No, Mr. Nath, this is the hard copy.
Lordship.
The hard copy has attestation.
Lordship.
This is the soft copy.
Lordship.
Soft copy does not have the attestation.
Lordship.
But this was not the additional document. This document was very much here.
But the condition of the tender provides that if there is, I'm just reading 17.1, page 57, the bidder shall submit both technical and financial bid through online, one hard copy of technical bid along with the supporting documents as per ITB, and clearly marked hard copy of technical bid. In the event of discrepancy between online and manual technical bid, the bid will be cancelled. So his online copy consists of many pages, which the hard copy doesn't contain. Kindly see in the online copy, there are many documents which are not available in the hard copy. So there is a discrepancy as per 17.1. Yes. Again, Roman 3. The hard copy of the technical bid supporting documents self-attested of the ITB shall be signed by a person or persons duly authorized to sign on behalf of the bidder. All pages of the bid where entries or amendments have been made shall initiated by the person or person signed the bid. But he has to put an index. The bid should be provides that bidder should invariably submit an index, contents of documents submitted mentioning the sequence of documents along with the hard copy of the technical document of the bids. But the index he has given in the hard copy, and according to that, kindly see the number of pages he has given is in the additional affidavit we have mentioned. It is
Here you, in your affidavit at running page 121,
Lordship.
You say the reason being that in the middle, page 3 of your affidavit,
my
Filed by the respondent number 4.
lordship. Respondent number 4.
In the middle. Respondent number 4 is Mr. Chaudhary.
We are 4 member.
No, respondent number 4's affidavit is not relevant much.
But kindly take up the additional affidavit filed by the respondent number 2.
Respondent number 2, one
So,
affidavit has been filed.
Borsing Rongpei, he has filed one additional affidavit. There, we have said, has lordship got the additional affidavit.
Affidavit in reply.
The additional affidavit filed on 13th of September 21.
Got it.
Para 2.
Yes.
I am taking your lordship to paragraph 2, Roman 1.
Respondent number 2.
This is the
however,
discrepancies they have noted. That the online technical bit submitted by the petitioner contains altogether 88 pages, and the same are without any pagination. For the sake of brevity, the online copies submitted by the petitioner have been downloaded by the authorities, and on scrutiny found that many pages of the technical bit have not been attested by the petitioner. Technical bit submitted online is accessible by the petitioner as well as all the other bidders, and the same can be verified online as well as from the downloaded printed copies. The hard copy of the technical bit submitted by the petitioner contains total 60 pages, and the same are paginated from 1 to 57, apart from 2 pages of index and 1 page of challan copy. So the deponent states that as per clause 17(1) of the bid document provides that the bidder shall submit both technical and financial bid through online and hard copy of technical bid along with supporting documents as per ITB, and clearly marked hard copy of technical bid. In the event of discrepancy between online and the manual technical bid, the bid will be cancelled. Then free that further it is respectfully stated that although in the minutes of the technical bid, the ground of rejection of the petitioner has been mentioned as not admitted, scanned technical documents are not attested by the petitioner, by the bidder. But later on, during adjudication of the matter by the Honorable Court, it has been discovered that in addition to the ground cited above, another additional reason for rejection of the technical bid is also for the fact that there has been major discrepancies between the online and the offline bid of the petitioner. So, lordship, 28 more pages are there in the online copy.
Now, what has happened in view of this litigation? Are you going ahead with this tender?
Malad, the work,
What was the bid validity?
otherwise, Malad, the work is very urgent. for us.
Understood, but are you going ahead with this tender?
Malad, yesterday, I contacted them for the instructions. Immediately, they rushed, Malad, they given the instructions. So they have shown their urgency with the matter. Malad.
This work was to be completed within a particular period.
Correct.
Then, what was the bid validity of the petitioners or the respondent?
Malad, both the
Let's see the contract conditions for that. Because now another aspect will come in. If you give them there because of the litigation pending, yes, we accept that it has been the fault of the court, but then also, would they be accepting it on the same bid validity? Would it not work?
If they accept, we will proceed. If Malad, they raise any objection, then we have to take another.
Let us see the bid validity.
Lordship.
Page 56.
Bid validity clause 15, page 56. Bid shall remain valid for period not less than 180 days after the deadline date for
Then
bid submission.
the bid's gone. Don't you think so? Would they be agreeable for that?
Well, if they agree, then only we can proceed. It is up to. We have
Well,
to.
let him agree. Then only we can go ahead. Because if they don't agree, why should this go? Because otherwise it will also have a serious repercussion on them.
Detrimental to our interest.
Detrimental to them interest.
The cost escalation and all of
Because now what will happen is, today I set aside, they give it to you. Tomorrow, because as a lawyer, I've seen a lot of litigations to the effect where they say that now you have to take it out there, otherwise we are going to take your EMD.
if the clients are agreeable,
Then it is okay. But otherwise they will take up and say that we were going to impose upon you this penalty or year because we have accepted the tender of yours. That is a huge problem which happens. And it may not be possible for you to do at 180 days because that was in 2021.
But for the authority, we have.
We will do one thing, Mr. Chaudhary. We'll keep it tomorrow also. You take your instructions properly. You also take your instruction because this is a very important instructions. Because not taking that instruction, you also take your instruction whether you want to go because the bid validity is 1 year, 80 days. Because yesterday there was a matter of one matter of pertaining to what we call supply of dietary service in the hospitals. There was a stay to that effect for 2 years. The bid validity period is over. And now these people are not agreeing for that price. Because obviously their price. Now, that is a bid validity of 2 years they were not agreeing to. Yours is 180 days. You heard, Mr. You are there?
No, you're not sure.
Okay, none appears on behalf of the petitioner on call. Mr. D. K. Nath appears on senior government advocate, appears on behalf of the petition respondent state, as well as Mr. K. N. Chaudhary, the learned senior counsel, assisted by Mr. D. J. Das, appears on behalf of the respondent number 4. List the matter again tomorrow at 2 p.m. Because this is required. Otherwise, I could have dismissed for default, but you will have a serious consequences.
Yes.
You take your thing.
One learned friend says, but not agree.
Huh?
He has received the instruction, he is agreeing to do. Just now he has said. At this old rate.
Okay. At 2 p.m. The petitioner, the respondent number 4, shall file an affidavit as to whether the respondent number 4 agrees to the validity of the bid as the period of bid has already elapsed. Right. This will protect you.
Yes.
Otherwise, tomorrow Mr. Chaudhary will be caught.
Correct. That will be good for us. But the records, the online and hard copy,
You take
that will be
it. You produce it tomorrow. Huh?
Lodge. I'll put it.
Lordship, may I take the liberty of Lordship? Lordship, item number, Lordship, 4, Lordship. Lordship has fixed the matter with the PIL in the division bench, Lordship. In that matter, Lordship, there is an interim order, Lordship, in our favor, Lordship. That may be extended because it was extended till the next date, Lordship.
And then nothing is going to happen.
Much obliged, Lordship.
Item number 6 for motion.
Yes.
Regarding Lordship, graduate scale of pay Lordship. I am graduate general post Lordship. We have challenged the improved order dated 22/2020, case number 70. Lordship.
Yes.
My
Mr.
lord, here
UC
Madras, Assam Madrasa Education Provincial Service Rule has been repealed, my lord. 2016 has been repealed. And my lord, now it is new act is come and all the teachers of Madrasa are coming to embed of the Assam Secondary Education Provincial School Service Rule 2018, my lord. So, my lord, in this regards, my lord, for graduate teacher, my lord, B.Ed is required, my lord. So he has no B.Ed, my lord, yeah. And he cannot claim the graduate scale of pay, my lord.
Yes, Mr. Counsel. Education men. You are relying upon a wrong interpretation. Where is that order you are challenging?
Case number 70. Lordship.
Huh?
Case number 70. Lordship.
70. Okay.
Yes.
What is mentioned in the last page 70, Mr. Sharma? Tell me.
Here,
a teacher, as per Rule 14 of the Assam Secondary Education Provincialized Rules, Service Rules 2018, a teacher of the high school should be a graduate in a particular stream or subject with BTD. Meaning?
Yes. B.Ed is required, my lord.
No, that's Assam education, which one?
Provincialized
Rules, Service Rule 2018.
Provincialization of service of non-teaching staff of venture, no.
No, my lord, teaching.
Sorry. Madrasa. Assam Madrasa Education, Provincialization of Service of Employees and Reorganization, Madrasa Educational Act 2018.
My lord, Assam Madrasa Education Provincialized Service Rule 2016 is repealed, my lord.
Repeal.
Yes.
Now we are concerned with?
We are concerned with the minor the secondary Assam Secondary Education Provincialized School Service Rule 2018, my lord. And as per
Just
this
one
rule,
minute, just 1 minute. Assam Secondary Education Provincial Service 18.
Page 18.
These are done under the provisions of Assam Secondary Education Provincialization. Under 309 is pleased to make this here. This is Rule 14.
Posting is related to
Recruitment to the post of headmaster superintendent. Why this we are concerned? What is this Rule 14 they are referring to? We are concerned about graduate teacher.
my lord, kindly come to the page 55, my lord.
Page
55. Assam Secondary Education Provincialized Schools Rule 2018. Graduate teacher, my lord, here. Graduate, postgraduate, recognized in from recognized university with at least 50% marks in either graduation or post-graduation or its equivalent and a bachelor education BEd from the National Council for Teachers Education recognized institution, but degrees obtained from off-campus and distance education institutions shall not be considered as valid. So BEd is required, madam.
This rule was given effect from 10 October 2019.
Huh?
This rule was also given effect from the date of 10 October 2019. Like we are not the new recruitee. We were appointed in the year 1996.
But you have not got the entitlement to the graduate teacher till now.
My lord, we were given and we received the graduate school from 96 to 2017.
You have got it.
Yes, thereafter, lordship, some person, similarly situated person, they approached this honorable court saying that there is a particular notification in the year 1993. Relying that notification, lordship, they claimed the same benefit. The honorable court saying that that notification cannot be applicable for the teacher of madrasa because that was only for secondary school, not for madrasa. Although that benefit was given to all the employees. Thereafter, after various rounds of litigation has taken place.
Heard Mr. M. Khan, the learned counsel, appearing on behalf of the petitioner. Mr.
U. Sharma, my lord.
U. Sharma appears on behalf of the respondent number 1, 2,
4 and 5.
4 and 5. Mr. Arba Pujari appears for the respondent number 3. Issue notice making it returnable on 26th of July 2023. As the respondents are duly represented, extra copies of the petition be served upon them during the course by today's first. 31st, no? By 2nd of June 2023. The case of the petitioners herein is that the petitioners were receiving the graduate pay up scale from 9/9/1996 till when?
2017.
You are not aware.
Some of the teachers are still getting graduate skill.
Huh?
Some of the teachers.
Some of the teachers mean how much course fee you have paid?
Here in this case, lordship, only one.
Huh?
Here only one petitioner.
Then we are concerned till when did you receive it? You are not aware.
Your lordship, there was an issue. I'm giving the date first. 3rd November 2017.
Till?
From 1996 to 3rd November 2017.
How can it be? When the letter of 5th of July 2017 you have challenged it?
Yes.
Then how can it be?
Prior to that, lordship,
You are not aware. Take time. Read the file and then come back to this court. The case of the petitioner is that the petitioner was being given the graduate scale of pay since 9/9/1996. However, subsequently, the said graduate scale of pay was stopped. Full stop. But when they too, there were various litigations. And by the order dated 2023, the Department of School, Secretary to the Government of Assam Department of School Education have held that the petitioner is not entitled to the graduate scale of pay as the petitioner does not have the, you are a graduate, does not have the BT/BTAD degree, which is required as per Rule 14 of the Assam Secondary Education Provincialized Schools Service Rules 2018. The respondents in the Education Department shall apprise this court on the next occasion as to why the petitioner would not be entitled to the graduate scale of pay.
7,
Made this order. My lord, this matter, my lord, relates to my lord, non-issuance of NOC by the BTC authorities, my lord.
Oh, that matter?
Yes, my lord.
Same order.
Kindly see page number 44, my lord. Same matter.
How many petitioners?
One matter.
But it is not similar because
Then I passed one more shorter order, na?
thereafter Lordship had passed some sort of order, but this person he was appointed in 2016, qualifying 10 years, he has not done it. 2016, this is completely different.
You reject it.
Lords, that qualification 10 years has not been completed.
But if we see the 10, it is one of the conditions. You see, it is not paramount that it needs to be.
The clause number.
Clause 10.
No, my lord, clause 7. Before that, clause 7, my lord.
No, 10, it is given out here, clause 7. The government and the companies shall be guided. You see, it is not paramount. It is guided by the following norms in the respect. In so and so or more can apply for remand to his or her district to the nearest so and so. So they will be guided. Take the guidance.
If Lordship turn to page number 22, Lordship. No.
You rejected it?
No, madam. There's a clause 7A. A teacher working in different contingents for 10 years or more can apply for transfer to his or her home district or to the nearest contingencies district. Else they have to qualify for 10 years. And this person, particular petitioner has been appointed on 2016.
Where is the appointment?
Appointment Annexa A. Annexa 1, my lord. It starts from page number 14. And this is dated 27 June 2016. This serial number in the next page, my lord.
Page number 14.
This one Kishore Roy.
Hello, rejected. Here's your name.
My lord, S. Das, my lord. Yes, that's my lord.
As the third, Mr. S. Das, the learned counsel appearing on behalf of the petitioner. Mr. S. Bora appears on behalf of the respondent number
2, 4, 5 and 6.
5 and 6. And Mr. P. N. Sharma appears for the respondent number 1 and 3.
1 and 3.
The instant writ petition has been filed by the petitioner. Now, the instant writ petition is taken up for disposal at the motion stage itself. Taking into account the facts involved. In the instant case, it is be seen that the petitioner was appointed on 27/6/2016 by the Director of Elementary Education, and the petitioner was appointed as the assistant teacher of Motowari LP School, Dhubri. Thereupon, the petitioner joined his service on 29/6/2016. The petitioner subsequently applied for transfer to where?
My lord, Baksa, my lord, home district.
To Baksa,
Yes.
to the district of Baksa,
And my lord, the concerned.
as it is the home district of the petitioner, home district,
Yes, my lord, the concerned BU has submitted that he has no.
home district,
Page number 30. it will be.
by the online process on 26/10/2022. It is relevant to take note of that the block elementary education officer, Baksa, Musalpur, had written a letter dated 31/2023 to the district elementary education officer, Baksa, Musalpur, that his office has no objection to the transfer of the petitioner. Thereupon, the district elementary education officer, Baksa, have also written to the director of education, BTC Kokraja, thereby forwarding the request of the petitioner for transfer. Subsequent thereto, the director of education, BTC Kokraja, forwarded the letter to the secretary education department by the communication dated 21/2/2023. However, as the relevant NOC has not been issued by the secretary
Yes, ma'am.
of the school department, the present writ petition has been filed for a direction upon the respondents to consider the application of the petitioner seeking transfer, which is pending for grant of NOC by the BTC authority. But it is pending before the Secretary Education Department.
He is going from Assam to BTC.
No, this is pending before whom?
Secretary Education Department, my lord, BTC.
So there is a Secretary Education Department, BTC also.
Yes. And page number 10, page number 39, madam. And accept 10. Let's make it clear, madam. Secretary.
The learned counsel appearing on behalf of the BTC, Mr. S. Boras, had drawn the attention to section 7 of the Assam Elementary and Secondary School Teacher Regulation of Posting and Transfer Act 2020, wherein it has been mandated that the inter-district transfer, wherein the inter-district transfer norms of the teachers have been mentioned. It is the requirement of section 7A that a teacher working in a district continuously for 10 years or more can apply for transfer to his or her home district or to the nearest contiguous district. In view of the mandate under section 7 of the Act of 2020, this court cannot issue a direction directing the respondents to consider the application of the petitioner. Considering the above, the instant petition stands dismissed.
My lord, may I submit one thing, my lord? My lord, the first petitioner, my lord, this Sorvana Newpane, he was also appointed by the same order, my lord, as per the same notification, my lord, on 27 June 2016. On the same appointment order, all the appointment, these teachers were appointed. So, my lord, he was also appointed in that 2016.
So that was not the question which I have stated out there, because he never raised that issue.
No, my lord. He
Now,
also,
can I, in view of section 7 be given,
yes.
how can I take care of it? You give me a good reason. You tell me, how can I?
Now,
Tell me, how can I? In fact, before you, there are 2 other petitions which I have written on that ground, on this section 10 business. Then they were showing section 10, section 7. Then they were showing section 10, that there are other reasons on which section 10 can be gone into. Wait for 3 years. You can. It is however observed that the petitioner could be at liberty to apply after completion of the 10 years.
Much of. My pleasure. Lordship, this matter is for releasing some unpaid salaries, Lordship, releasing to the service of my father. Then, Lordship, area of family pension and other service benefits, Lordship, including the DCS. Lordship, my case is that, Lordship. My father was initially appointed as an assistant director on Lordship under Rule 3 of Lordship on 2/1/1991. Annexer Lordship case 14. Case 14 Lordship.
Mr. Counsel, you are asking for what?
Lordship, areas, salaries Lordship, with effect from Lordship 1/4/2001 to Lordship 9 March 2009 Lordship. Lordship, the fact is that he was appointed in the under the non-formal education.
When did your father die?
Father died Lordship on Lordship 16/7/2000, Lordship 19/5/2017 Lordship.
Then why didn't you raise it at that point of time when he was there?
Lordship, I am going to that Lordship. Thereafter, my mother applied Lordship. It was forwarded to the Accountant General Office Lordship, and it was the Accountant General returned the same with observation, which is a case Lordship 29. 16/7/2018. It was returned by the Accountant General.
Then,
Lordship, one of the representation of my father may kindly be perused, Lordship, which is a case 25. Lordship, there is a background in this case, Lordship.
and what is this family pension business?
Lordship, family pension. After the death of my father, my mother applied for family pension, Lordship, and it was returned by the Accountant General, Lordship, with observation. Basically,
Your mother is there?
Mother died, Lordship.
Then where is the question of family pension?
Lordship, but she is entitled to the family pension.
But she is not there.
Lordship, but being the legal here, Lordship, I am entitled to the area of family pension.
Family pension question doesn't arise.
Lordship, area of family pension.
No area of family pension, whatever may be. She didn't receive it. That family pension is for her only.
Lordship,
Nothing to that. Area pension, this area thing, this can be considered, but not the family pension.
Lordship,
You are not a family.
no, I am
You
the
are 37 years old.
I am the son, Lordship, but I am.
So what? You have no business out there. We can consider only as regards your area salary.
And the other service benefits, including the DCRC, I am also entitled in the legal here, Lordship. Legal here is also not released, Lordship.
Where have you asked for the DCRG?
Lordship, including the DCRC, I have in the prayer portion, Lordship.
You know, they are including the DCRG. The DCRG word is missing. Mr. Sharma, do you see DCRG anywhere in the prayer?
I have not found, Lordship.
I also not found.
No, it is not there, Lordship. Releasing the area.
Other service benefits relating to service of his father. Other service benefit includes the DCRG, Lordship, GIS also, Lordship.
And?
GIS, DCRG. And
But not the family pension.
family pension, Lordship.
No, I'm
Which was entitled to my
I'm putting a
mother.
full stop to the family pension business. Heard Mr. H. Talukdar, the learned counsel, appearing on behalf of the petitioner. Mr. P.N. Sharma appears on behalf of the respondent number
1, 2,
3,
3, and
4,
4.
Mr. R. Balpuzari appears for respondent number 5. Mrs. S. Burwa appears for the respondent number 6. Mr. R. Dhar appears for the respondent number 7. Issue notice making it returnable on 28th of July 2023. As the respondents are duly represented, extra copies of the petition be served upon them by 2nd of June. The case of the petitioner herein is that the petitioner's father was entitled to the area salary for the period from 1/3/2001 to 8/3/2009. Further to that, upon his death, upon his retirement,
Not retirement, Lord. Upon his death.
after his death, further to that, it is the case of the petitioner that the husband of the petitioner, that the petitioner's father expired in harness. And as such, harness on
On 19/5/2017, Lord.
19
May.
19/5/2017. For which the petitioner is for which there would be area compassionate family pension as well as other service benefits, including the DCRG and the GIS, which the husband of the father of the petitioner would have been entitled to, which a mother of the petitioner would have been entitled to. However, the same having not been paid, the instant writ petition has been filed. It is apparent from paragraph annexure K of the writ petition that the senior accounts officer of the Office of the Accountant General AE had returned the proposal for the area salary for the period from 1/3/2001 to 8/3/2009 on account of certain deficiencies which were to be fulfilled at the end of the respondent education department. However, it is the case of the petitioner the same was not done, for which the said area salary for that period was not given, has not yet been disbursed. This court further taking into account that the petitioner at present is 37 years old and would not come within the ambit of family as defined under Rule 143
Yes. 143, Lord.
of the Assam Service Pension Rules 1969, is of the opinion that the petitioner would not be entitled to the compassionate family pension. However, the petitioner would be entitled to the DCRG as well as the GIS, which the petitioner's father would have received had he been alive. Considering the above, the respondents in the education department shall apprise this court on the next returnable date. As regards what steps have been taken pursuant to the communication by the senior accounts officer of the Office of the Accountant General AE, enclosed as Annexure K to the petition, and further as to whether the DCRG as well as the GIS amount was payable to the father of the petitioner or was payable to the mother of the petitioner upon the death of the father of the petitioner in harness.
Lordship, may I point out one thing, Lordship, in paragraph 13, Lordship, although the petitioner has stated that the mother has died, but to that effect, there is no any death certificate has been annexed. Lordship, I have annexed, Lordship, I have stated, Lordship. Only there is a statement.
The petitioner is further directed to file an additional affidavit bringing on record the death certificate of the mother.
No, 9.
Petitioner was appointed as a helper, my lord, in the health department. On 17/7/1987, my lord.
On, my lord, 19/10/2016, my lord, he was placed under suspension with effect from 15/6/2016, which your lordship will find at page number 22, my lord. If your lordship kindly turns to page number 22.
Then
Thereafter, my lord, he was granted subsistence allowance, half the pay. 3 months exceeded, my lord, more than 3 months. Then they increased the subsistence allowance. In fact, there was a notification, communication to that effect in page 26. But the benefit of those communication didn't percolate, my lord. Page number 26, if your lordship kindly turns for a moment.
you didn't get that amount.
No, my lord. Page number 26, my lord. 24 Jan 2017, my lord. It says, in continuation of this office order number so and so, my lord, dated 2/11/2016, the subsistence allowance in respect of Sri Toroni Rajbongsi helper, HARD Guwahati, who was placed under suspension by this office number so and so, my lord, dated 19/10/2016, with effect from 15/6/2016, is hereby increased by a suitable amount not exceeding 50% of the subsistence allowance admissible during the first period of first 3 months as per provision 1 of rule FR 53(1)(2)(a). So this is what we are claiming, my lord.
You are claiming the subsistence
allowance.
During which period?
From 16/9/2016 to 22/6/2017.
Thereupon, you have been.
I've been reinstated. My reinstatement order is at page number 29.
Heard Mr. A.K. Burwa, the learned counsel, appearing on behalf of the petitioner. Ms. S. Sharma appears on behalf of the respondent number 1, 2, and 3. Issue notice making it returnable on 24th of July 2023. As the respondents are 1, 2, and 3 are duly represented, extra copies of the writ petition be served by 2nd of June 2023. The case of the petitioner herein is that the petitioner is entitled to the area subsistence allowance so payable to the petitioner for the period from 1/6/2016 to 22/6/2017. Which have not, however, been paid by the respondent authorities. Taking into account the same, the respondent authorities are directed to apprise this court on the returnable date as to why the said area subsistence allowance of the petitioner have not been paid. Then
the petitioner was arrested, my lord, on 15/11/2022. Thereafter, in connection with vigilance PS case number 4 of 2022, my lord. And thereafter, he was placed under suspension, which your lordship will find at page number 28, my lord. Page number 28, my lord. 18/11/2022.
Then
it says, my lord,
you are released on bail on 16/12.
correct, my lord. On 16th,
Then
I was released. I was given a show cause notice on 26/12/2022. I replied, responded to the same, my lord.
Okay, then
I've been kept under suspension, my lord, since then, my lord. No order for extension, no reasoning. Neither there has been any review exercise undertaken with regard to the continuation of that suspension, my lord. And therefore, I am before your lordship because, my lord, on 21/1/2023, they give me a letter stating that I am going to superannuate on 36/2023. So, my lord, more than 6 months has elapsed. And not even the review exercise has been undertaken, and I'm going to retire very soon, my lord. Therefore, I am before your lordship, my lord. In fact, there is an OM, my lord. That OM relevant portion is at page number 16.
There is a similar order, lordship, past page of cases. So 4 cases were there.
Same case.
Same case. Allowing me 15 days time to take a decision.
My prayer is very limited before your lordship, my lord. All I am praying, my lord, page number 16, if your lordship kindly turns, my lord, that OM dated 4/2/2020. It says, my lord, after issuance of memorandum of charges of the charge sheet, the senior most secretaries will undertake a review within 6 months as regards a desirability to further continue with the suspension order. That is what I am praying, my lord. Very limited prayer before your lordship.
that is what I have passed an order earlier. This is it.
It's
Petitioner has submitted a reply on and the disciplinary is presently going on ahead with the discipline that this court does not find any justifiable ground for interference with the suspension order. However, it is made clear that it is the mandate of law there has to be an extension of the suspension order by reasoned order, which as per the office memorandum is to be done within a period of 6 months. Taking into account that the learned counsel appearing on behalf of the respondent number 1 submits that the same would be done within a period of 15 days from today, this court is not inclined to interfere with the order of suspension or the further continuation of the service, subject to the respondent authorities passing a reasoned order within 15 days from the date a certified copy of this order is served upon the Commissioner GMC. In respect to the question pertaining to the quashing of the disciplinary proceedings on the ground that there is a criminal. Are you asking? No.
no, I'm not asking for the quashing or setting aside of the disciplinary proceeding.
So we go direct him only these 15 days you do it.
With regard to the desirability of the continuation.
Absolutely. नाम की बदलाई दी हाँ मिस्टर A.K. Burwa over A.K. Sharma only as Bora and Mrs. S. Burwa appears. Huh?
I'm appealing for all the respondents.
Oh,
1, 2, 3.
Oh, only 1, 2, 3 is there.
Only 2.
For the respondent number 1, 2, and 3. Taking into account the petition has challenged the order of suspension dated.
My lord, it is my lord 18/11/2022, my lord.
18/11/2022. You are not challenging departmental proceedings.
Not that I'm not challenging, my lord. I'm only challenging the suspension order.
It is a contention of the petition that the order dated 20/18/11/22, whereby the petitioner was whether is contrary to the law laid down by the Supreme Court in the case of, and more particularly paragraph wherein it has been mentioned that even after the memorandum charge has been served upon the delinquent employee, the authority has to pass a reasoned order for extending the suspension, which has not been done in the instant case, and as such the petitioner is entitled to reinstatement. And on the other hand, Mr. S. Bora, the learned counsel appearing on behalf of the JSC submits that the judgment of the Supreme Court in the case directions were issued to the effect that upon serving the memorandum of charge upon the delinquent, a reasoned order has to be passed for a year. And submits about the office memorandum dated issued by the Chief Secretary in the Personnel Department, where it has been mentioned a review has to be made within a period of 6 months from the date of submission. Appearing on submits that the memorandum was served upon the when was the memorandum given to you?
26/12/2022, my lord. 26/12/2022, my lord.
26/12/2022,
my lord.
And as on date, the period of 6 months is not over.
It's over, my lord, in my case.
Huh?
It is over, my lord.
How can it be?
No.
26/12.
5 months, 4 days.
Then 6 months is not over.
No, I have calculated 5 months, 4 days.
Would be taken within 15 days from today if such steps had not been taken. On submission of so then it and memorandum was charged was submitted on the email. The petitioner has also submitted a reply on.
My lord, 6/1/2023, my lord.
Together with other fellows.
My lord, 6/1/2020.
And he is presently with the criminal proceeding. This court is does not find any justifiable interference. However, it is made clear that it is the mandate of law, and when you are taking into account that he must have submitted, disposed. Within 15 days, huh?
I'll give certificate.
Yes, madam.
My lord, this matter relates to non-payment revised scale of family pension and gratuity to the petitioner, my lord, as per 6th and 7th pay commission, who is the widow and legal heir of the deceased government servant, my lord.
Pay the family pension of the
She is
petitioner
receiving only
at an enhanced
4,091,
rate,
ma'am.
revised rate as per the 6th schedule, the 6th and the 7th petitioner whose husband late so died on Iman after retiring of their service as Chokidar in the office of the Iman and who has been receiving monthly pension from 1 till date. You are getting your family pension?
Yes, my lord.
You are only asking for revised.
4,091, only 4,091, my lord.
You want more than that?
Yes, my lord.
Which department, who is appearing? Who appears for the this secretary? Planning and Development Department, now known as Transformation and Development Department.
Yes, we are.
Director of Economics and Statistics. Director of Deputy, you are appearing for those?
Yes,
Economics and
Lordship.
Statistics.
Yes, Lordship.
Okay. Or Ms. S.B. Chaudhary, the Learned Counsel, appearing on behalf of the petitioner. Mrs. S. Burwa appears on behalf of the respondent number 1, 3, 4. Yes, madam, you are appearing for?
For respondent number 5, Accountant General, Peace Varghese.
So and so appears on behalf of the respondent number 5. Mr. Arbo Putari appears for the respondent number 2 and 6.
Lordship, we have not received copy, Lordship, and our name has also not shown in the copy.
Issue notice making it returnable on 2nd of August 2023. As the respondents are duly represented, extra copies of the petition be served by 2nd of June 2023. The case of the petitioner herein is that the petitioner is presently receiving a family pension at the rate of 4,091 per month. The petitioner is aggrieved by the inaction on the part of the respondent authorities in not granting the benefit of the 6th and the 7th pay commission insofar as the family pension of the petitioner. The respondents shall apprise this court on the next returnable date as to why the petitioner have not been granted, as alleged, the family pension and the benefit of the 6th and the 7th pay commission. The registry shall show the names of the SC Finance name has not been shown in the list. Shall show the name of whom? Of Mrs. S. Burwa, the Learned Counsel, appearing on behalf of the respondent numbers
1, 3.
1, 3, no.
1,
1,
3,
3,
4.
and 4.
May it please your lord. It's an application for vacation of an.
Lordship,
filed in.
I am the petitioner, Lordship. I have received opposition in affidavit. I want to file rejoinder and reply. So my humble prayer before your Lordship to give us 2 weeks time to file this, Lordship.
Already he is enjoying a.
Okay, is this order passed under?
And interim maybe continue till.
Understood, but is this an order passed under 226(3)? Ex parte?
Ex parte.
So what do you say about 226(3) applying? Isn't it the mandate under Article 2263 that it has to be disposed of within 14 days? Today is the 14th day.
Lordship.
And you were served on the 17th of May. Don't you
Also,
think?
kindly, my humble
Understood.
prayer.
I'll vacate the order. Then you can do whatever you feel like. Because that is the mandate of law.
Till next day, Lordship.
But how do I
Kindly
do it?
consider,
No, how
Lordship.
do I extend it? Tell me, isn't it the mandate of law? What is it? Requirement
I'm
of what?
fast track,
What is it? In view of the prima facie case, what is your case, petitioner? What is your case?
I am first wife, Lordship. I have deprived second wife and has usually obtaining the family pension, Lordship.
So, what have you asked for?
My humble prayer on my petition.
So you are asking for setting aside of the payment pension order
Yes, Lordship. And
given in the name of the second wife.
second wife,
Okay, because you are the first wife.
first wife.
Fantastic. Now, if it is you are the first wife, what right do you have, Mr. Counsel?
Lordship, what The order was taken by way of suppression of a material fact. In fact, she
Lordship,
was
let
divorced. She was divorced, Your Lordship, and that certificate we have enacted.
You have
She is no more
enclosed?
a wife. That in the IA, Your Lordship will find.
Where?
Divorce is page 23 starts under the Muslim Marriage Registration Act.
Divorce, date of divorce 7/1/2017. Divorce, Talaki Hassan. And I hereby pronounce the talak. So, is this wrong?
Lordship?
There is some defect, Lordship. We will clear it, giving reply, Lordship.
Hello.
Lordship, we also
Now
challenge
tell
it
me one thing, what stay you have got?
that I was receiving the pension.
That should be stopped. Necessarily, let her get.
Yes.
What is that? You prove yourself.
Yes.
I vacate it, that order, and then you do one thing. Don't worry, I'll finish up the matter if I am there. Heard, Mr.
Zita.
G.J. Ahmed.
Yes.
The learned counsel appearing on behalf of the petitioner. And Mr.
I am petitioner, Lordship. Main petition, I am petitioner, Lordship.
Your name?
B. Khaklari, Lordship.
B. Kakleri, the learned counsel appearing on behalf of the respondent number, opposite party number.
She is one girl.
Opposite party number one. The petitioner in the writ petition. This is an application filed under sections, application filed for vacation, modification, and alteration of the order dated 9/12/2022, passed in the accompanying writ petition. From a perusal of the said application, it transpires that the said application was filed by serving a copy. Hey, copy ketia korche sao? Serving a copy. When did you get the copy? Right? When did you get the copy?
Lordship.
Second copy to good. I second copy nothing. Date of receiving by serving a copy on 16/5/2023. By serving a copy on 16/5/2023. A perusal of the said application shows a perusal of the order by which have been sought to be vacated, which was sought to be modified by the application. A perusal of the order dated 9/12/2022 on which have been sought to be vacated, modified by the application, reveals that the said order was passed ex parte against the respondent number 7, that is the applicant herein. Today, when the matter is taken up, the learned counsel appearing on behalf of the petitioner Public the respondent, opposite party number 1, 6 for an accommodation. However, it appears from the application which was filed that there is a serious allegation of suppression of material facts, in as much as from annexure
3, page 20.
3,
Page 20.
it is apparent, it shows that the opposite party number 1 petitioner herein was divorced on 7/1/2017. The learned counsel appearing on behalf of the opposite party number 1 petitioner submits that he has no instructions on that.
I have instructions.
Yes, what is that?
Lordship, they submitted these fraud documents. Even witness is fraud, she instruct me, Lordship. So I will clear it after I will file the reply, Lordship.
You have not filed it. I can't help you. You have got the copy. Why didn't you file it? This is not a simple document. This is a document before the marriage register. Taking into account the above, this court prima facie is of the opinion that the petitioner is not entitled to the interim order. Dated 9/2/2000, interim order, as was passed by the order dated 9/12/2022. Accordingly, the interim order dated 9/12/2022 stands vacated, whereby the petitioner, the applicant herein, will be entitled to the family pension, shall continue to receive the family pension. It is, however, observed that the family pension so received by the applicant, public the respondent number 7, shall be subject to the outcome of the writ petition. And in the circumstance that the petitioner is successful, the petitioner would be entitled to the said family pension so received by the respondent number 7. Is the matter well? You have urgency now.
2 weeks, Lordship. After 2 weeks.
When are you filing your reply?
2 weeks. Kindly allow me 2 weeks, Lordship.
I'll grant you 2 weeks, but 2 months I will grant you. But
2
it
weeks,
is your
Lordship.
urgency. You want a quick disposal of the matter now.
Lordship.
I since dispose. Yeah, it's the main matter to deal. The learning counsel for the petitioner submits that he's sick. He needs an accommodation of 2 weeks for filing the reply. Taking into account the same, this is the matter on 26th of June 2023. So the affidavit be filed, in reply be filed by 23rd of June. Okay. The main petitioner, an attempt shall be made to dispose of the writ petition on the next.
Much.
Oh, that matter, graduate.
Lordship. Lordship, no, there is no such document, Your Lordship.
Then,
I think what they have given me is a 2011 office memorandum, Your Lordship.
Mr. Dotto, the learned appearing on behalf of the petitioner submits that the said instruction so produced does not clarify the query so raised in the order dated demand, in as much as the petitioner herein became a part of the secondary education department in the year 2006. And unless and until the notification dated so and so as well as so and so have not been withdrawn, amended, modified prior to a month, the petitioner would be entitled to the benefit of the said notification. What is your office memorandum? This is the same thing you produced on the last occasion. I've seen this. Yes, this document you have already produced it. And it is on the basis of this document he has been denied. Well,
This was not placed, Your Lordship.
Madam, you placed it on that day. I'll give it and give you with particulars when you gave it. Yes, you placed it on 26/4/2023. In pursuance to the order dated 27/3/2023, the Learned Counsel appearing on behalf of the Secondary Education Department has produced the office memorandum dated 18/11/2011. The same is kept on record and marked with the letter Y.
Lordship.
In fact, on that day, you were not present. That must be the reason why.
Lordship.
Then
Lordship.
he's entitled to.
Lordship. Because they say they have no such record, Your Lordship.
Heard Mr. M. Dr. the Learned Counsel appearing on behalf of the petitioner. Ms. D. Musairi appears on behalf of the respondent number 1, 2, 3. Mr. Arbor Pujari appears for the respondent number 4. None appears for the respondent number 5. The case of the petitioner herein is that the petitioner was initially appointed as an assistant teacher, Arabic, in Andabhanga, ME Madrasa in the Borpeta district on 12/3/1977. At that relevant point of time, the school was a venture institution. Subsequent thereto, the service of the petitioner was provincialized at the time of provincialization of the school. And thereafter, in 1997, the petitioner was transferred to the CAIME, all caps, ... Madrasa. And in 1999, the petitioner was transferred to Khilabari ME Madrasa. It is also mentioned that on 30/3/2001, the petitioner was again transferred from Ghilawari ME Madrasa to Nayator Konapur ME Madrasa by the order of the District Education Officer Kamrup. The said Noyatora's Hunapur ME Madrasa was amalgamated with the respondent number 5 school, while an order of the Director of Elementary Education Assam dated 27/11/2006 Pursuant to such amalgamation, the petitioner and other teachers of the ME Madrasa stood absorbed in the amalgamated high school, and an amalgamated seniority list was prepared. It has been further stated in the petition that on 26/12/2006, the inspector of school, Kamrup District Circle, by the memo bearing number PI bracket AMAL /2005/01/1209-66, issued to the headmaster of the respondent number 5 school, directing that the qualified staff of the ME Madrasa serving against duly sanctioned posts stood absorbed in the high school without prejudice to the upgradation of the scale of pay of the teachers working in the intermediate scale of pay. The petitioner figured at serial number 10 as assistant teacher with qualification recorded as MA and the date of joining as 12/3/1977. It has been further mentioned that one Muhammad Zabed Ali was working as the assistant teacher, Arabic, and was posted as serial number 5 of the seniority list dated 26/12/2006. And the said Zabed Ali retired on 30/3/2011 on obtaining the age of superannuation. Under such circumstances, the petitioner submitted a representation on 9/1/2012 to the Inspector of Schools, Kamrup District Circle, for upgradation of his scale of pay from intermediate scale to the upgraded scale. However, the same was rejected on the ground of inverted comma no provision. Being aggrieved, the petitioner therefore approached this court by filing a writ petition which was registered and numbered as WPC number 1642/2014. And this court, by an order dated 6/8/2014, disposed of the said writ petition, directing the respondent number 1 to consider the case of the petitioner and pass appropriate order. It further appears on record that on 16/12/2014, the Secretary to the Government of Assam Education Secondary Department rejected the case of the petitioner for upgradation of the teachers in intermediate scale to the post of graduate teacher have been discontinued by the OM number ASC 58/2010/53 dated 18/11/2011. The petitioner, therefore, being aggrieved, have challenged the order dated 16/12/2014 passed by the Secretary to the Government of Assam Education bracket Secondary Department, as well as the office memorandum dated 18/11/2011, which was the basis for passing the order dated 16/12/2014. The petitioner further also sought for a mandamus directing the respondent authorities to grant the graduate scale of pay to the petitioner from the date of amalgamation of Nayatar Hunapur ME Madrasa Kamrup Assam with the respondent number 5 school. It may be relevant here to mention that at the time when the petitioner filed the writ petition, he was 56 years. And by now, the petitioner has already crossed the age of superannuation. The record reveals that there is no affidavit which has been filed by the respondent authorities. Be that as it may, on 26/4/2023, the office memorandum dated 18/11/2011, which has been put to challenge, was produced before this court, and the same has been kept on record and marked with the letter Y. In the office memorandum, from a perusal of the office memorandum, it reveals this court, by the order dated 26/4/2023, observed as follows: paragraph 3, 4, 5, 6. Court koi dibo. Chalo. In pursuance to the order dated 26/4/2023, the Learned Council, appearing on behalf of the secondary education, had submitted on 3/5/2023 had placed a set of instructions issued by the Director of Secondary Education, wherein reference was made to an office memorandum dated 30/12/1993, which stipulated that the existing post of assistant teacher in intermediate scale of pay of rupees 1185-2395 per month, with graduate incumbent of provincialized higher secondary school in the post of assistant teacher to be entitled to graduate scale of 1375-3375 per month from the date of issue of the said order. It was further mentioned that the government notification dated 30/12/1993 was applicable in respect to those existing intermediate teachers working in the schools under the secondary education department at that point of time. However, as the petitioner was working in the elementary education department at that relevant point of time, and it was only in the year 2006 that the petitioner became a part of the secondary education department, the petitioner was not entitled to the benefit of the notification dated 30/12/1993, as well as the subsequent notification dated 7/2/1995. The said instructions were produced by the Learned Standing Council of the Secondary Education Department was also kept on record and marked with the letter Z. On the same date, upon hearing the Learned Councils and taking into account the submission made by the Learned Council for the petitioner, to the effect that the petitioner became a part of the secondary education department in the year 2006, and unless and until the notification dated 30/12/1993 as well as 7/2/1995 have not been withdrawn, amended, modified prior to 2006, the petitioner would be entitled to the benefit of the said notifications. This court directed the council appearing on behalf of the secondary education department to take instruction in the matter as to whether the notifications dated 30/12/1993 as well as 7/2/1995 was withdrawn prior to the petitioner's school having been amalgamated with the respondent number 5 school. Was withdrawn prior to the amalgamation. Was whether the notification stated so and so was withdrawn prior to the amalgamation of the petitioners of the Nayantar Hikon ME Madrasa with the respondent number 5 school. The Learned Council, appearing on behalf of the Secondary Education Department on 17/5/2023, could not obtain instruction, and today also submitted upon instruction that there is no such notification by which the notifications dated 30/12/1993 as well as 7/2/1995 was withdrawn prior to the amalgamation of a Nayantar ME Madrasa with the respondent number 5 school. Under such circumstances, this court is of the opinion that in view of the said notifications dated 30/12/1993 as well as 7/2/1995, the petitioner would be entitled to what is the scale you will be entitled to?
That scale immediately, of course, I don't have the instructions to put this present scale. Present scale, I am not.
No, not then. Would have been entitled to as per which scale?
My lord, the intermediate scale, my lord, was 1375 of dash in 1995 notation 1375-3375.
Would have been entitled to the scale of pay of 1375-3375 per month. Accordingly, this court therefore disposes of the instant writ petition, observing that the petitioner would be entitled to the benefit of the notification dated 7/2/1995, on the basis of which the petitioner's scale of pay ought to have been rupees 1375-3375 from the date of merger of that Nayantar Madrasa with from the date of madrasa or which one?
No, from the date of my lord, the retirement of the incumbent, my lord.
The retirement of
the 3011.
The madrasa Javin Ali. From the date of retirement of Muhammad Javed Ali, that is on 33/2011.
30/11.
You said 33.
No, that's a mistake, my lord. Then the representation is correct. 30/11.
Then 30/11/2011.
11. The lordship had referred to 33 earlier also, that will be correct.
To correct. 30.
That is, my lord, the lordship also refer to this scale, pre-revised scale. This is because this is the earliest scale. So, since this is 3375 is the earliest scale, so lordship will also use the word pre-revised scale.
Pre-revised. Pre-revised. On the basis of the above declaration, the respondents are therefore directed on the basis of the said declaration and taking into account that the petitioner have now retired. The respondents are directed to recompute the entitlement of the petitioner on the basis of the declaration for his area salary as well as also his pension and pensionary benefits. The same should be done within a period of 6 months from the date of service of a certificate copy upon the Director of Secondary Education.
Master or labor, helper, my lord. he was regularized employee, my lord, only because of some debt.
Yes, Mr. Hassan. Any
My lord.
instruction?
My lord, here what happened, my lord, before passing the judgment in Sanjita Roy, once the pension proposal was submitted, then my lord, we returned the proposal because of that after deduction of 6 years, he has less than 20 years. Now, my lord, again they have resubmitted the proposal, but in the proposal, my lord, they have calculated the qualifying service again after deducting the 6 years. So, my lord, we have only issued a letter, my lord, that whether the judgment of Sanjita Roy will applicable or not. Only that much. Otherwise, my lord, he is entitled, my lord.
Otherwise, my lord, he is 20 years.
The first and second point, my lord. And my lord, after passing the judgment in the Sanjita Roy, my lord, the department has not modified the office memorandum also, my lord. That is why, my lord, we are facing this problem, my lord. My lord, this is the letter, my lord. My lord, this communication was made to the Accountant General, my lord, after passing the Sanjita Roy. Here, my lord, the Commissioner and Secretary, my lord, Pension and Public Grievance, informed us that, my lord, as an interim measure, my lord, only the petitioners who were engaged prior to 1493 are entitled. And in the last paragraph, my lord, after
Mr. Das, you do one thing. Take these two documents, file an affidavit. I'll take it up on a Tuesday.
Yes.
I'll dispose it of by stating all these things and taking into Sanjita Roy went to division bench. And as such, I'll say that it is the law. And as such, everybody has to follow.
My lord,
I think that is
my
a
lord,
better
that will
option.
clarify, my lord, everything.
Let-
Otherwise, my lord, in
Let
each and
let Mr. Das be glorified for
My
what he
lord.
has done.
Otherwise, my lord, in each and every case,
Everything that they also have passed order there. Okay.
we are facing this problem, my lord.
You be the what do you call that? Wellington Christian. No? There are a lot of patriots out there, the freedom fighters, the first one.
Yes.
We'll let you be.
The Netherlands also mentioned this.
My lord,
I know that.
Yes.
So
Otherwise,
this
he is
needs to be done, and as such, a direction has to be issued to the director of
I am
pension.
supplying this to
Heard, the Mr. H. Das, the learned counsel, appearing on behalf of the petitioner. Mr. A. Hassan appears on behalf of the respondent, accountant general, and Mr. N. Upadhyay appears for the irrigation.
Lordship, 1284.
Who appears for pension and pay?
He has not made party lordship in this case.
Not made.
My lord, let the commissioner and secretary PPG, my lord, madam party, my lord.
Director of pension is not made a party.
Probably not, my lord. No, my lord.
To do, Mr. Counsel. Why have you not made director of pension? Who is going to pay? Accountant general.
Accountant general.
Okay. So, taking into account the issue involved, whereby in spite of the judgment of the division single bench of this court by the coordinate bench of this court in the case of Sanjita Roy versus State of Assam reported in
2019 to GLT 805.
805.
which have been further affirmed by the division bench of this court in the case of
Writ appeal number 18/20.
case of State of Assam versus
Yes, madam. Binapani Das versus State of Assam.
Minapani Das versus State of Assam in writ appeal number so and so, dated so and so,
Dated, my lord,
and
26 to 21.
and the fact that the respondents and the fact that the accountant general have been made to and is under and the recurrent returning of the proposals by the accountant general on account of not incorporating No, wasn't that notification set aside
No.
No, no, madam.
by in Sanjita Roy? That 2014,
2019 notification.
that was set aside?
No.
Not set aside.
What was it done?
After the
Only that portion was interfered with. That is the deduction of 6 years. My lord.
6 years, my lord.
Otherwise, my lord, they are entitled to pension only because of that OM, my lord, 25/2009.
What is there?
This is my
That notification, what does it say?
Here, my lord,
by which, my lord, for the first time, my lord, the pension to the
1493 aspect is mentioned here only.
What does it say?
Here, madam, mentioned in view of the above, in order to comply with the order of the Honorable High Court, this department as an interim measure concurs approval towards pension and other retirement benefits as admissible to the petitioner who were engaged prior to 1493 and retired as regular MR worker with at least 20 years of continuous service without any reduction. The pension and pensionary benefit in such cases shall be paid with effect from the date of following the retirement or from the cut-off date, that is to say 2005/2009 as laid down in office memorandum dated 4/10/2010.
Does it say here regularized?
Petitioner.
This office? Then if it is regularized, then how can a master roll worker, where you regularized?
Petitioner is regularized.
When?
And he was regularized,
2005, madam.
2005. 22/7/2005.
Mr. Hassan, that day, were you not appearing? I passed the judgment in the case of one of the petitioners. Wherein I think Mr. K.R. Padgiri was appearing. You were there, na? In motion only I allowed it.
No, man.
Applying that judgment of Uday Pratap Singh, wherein the Supreme Court says that a person having been regularized, and if he has worked for that, he has to be entitled to the pension. So, and when did you retire?
Well, I retired 31/5/2010.
2010.
So he had only 5 years.
Yes, my lord.
So 5 years, earlier 5 years is to be taken, qualifying service. That means he gets 10 years. Then it will be enough for that. Why should we go into Sanjita Roy? But because Sanjita Roy has nothing to do, because he is already regularized.
My lord, in Sanjita Roy case also, my lord, every master worker they were regularized in the year 2005.
But why do you need 20 years? You don't need 20 years. Can you have a 20 years when the pension code says only 10 years?
My lord, because they are, my lord, temporary government servant, my lord. They were
once you were regularized, can you say to be
regularized against a personnel post, my lord? That is why, my lord. Not
so regularized under the personal post. How does it make a difference?
And my lord, in the regularized order, my lord. My lord, page 10, my lord. Page 10 of the petition, my lord. The second paragraph.
Yes.
The posts are personnel to the incumbents concerned who are holding the post and will be abolished as soon as the concerned incumbent relinquish their post in any manner.
Now, if you see FR and SR,
my lord,
I think that is applicable. FR 231, what it says about what is a temporary post. And if it is a temporary post also, you don't need to be a permanent post for that.
And that we have to see, my lord. Otherwise, my lord, they are the temporary government employee.
No, the post is temporary, but the service is not temporary. The post is only, the retention is temporary, but not their service. Can you say their service is temporary? No. Does the government have any aspect of that? A person is only, you need to be in a, but he has to be only permanent. His service has to be permanent. And once he is regularized, he comes into the affairs of the service of the government.
But my lord, all the master workers, my lord, their pensions are governed under this OM of 2009, my lord.
Do you know why they are asking for?
Because my lord,
No, there's a reason why they are asking for. Which still now the government is not catching on it. If they go on this way, they will be entitled to the old pension scheme.
yeah,
But if you go under this 610 regularization, they actually will be entitled to the new one because they come into the affairs of the government only then. So that is not any ad hoc.
my lord.
That is why no petitioner wants to come to that ambit.
My lord.
There's the catch. So this aspect one has to be
And
keep
my
a
lord,
blindfold.
he has not also made the
But that is the main reason why all the petitioner councils don't do it. Because the moment, you see, once he's regularized,
my lord,
now apply the law as regards all other people,
my lord,
the teachers everywhere.
regular government,
Once you are regularized, you come into the fold of the government.
my lord.
And anybody coming into the fold of the government on from 1 to 2005, would he be entitled to the old pension scheme? No. That is why they are doing it on the basis thereof. And the government also doesn't want to look into that aspect. Until one fine day somebody comes up.
My lord.
Hello, we'll have it on some other day. You take this, file your affidavit, whatever one. This is the matter on when?
Any date, my lord, judicial. In this week or
Huh?
next week or in this week or
Next week I am only sitting for 2 days. Then I am no more.
Tuesday, my lord, then Tuesday.
I am getting rid of this pension bench.
Oh, then my lord, this week, my lord.
No, this. Let it come up after 2 weeks. Let the matter be after 2 weeks at a date. Any urgent matters?
Obliged, my lord.
I have to rise today.
Obliged.
Yes, Mr. Rahman.
My lord, my status score till today, my lord.
Which order?
Item 48, my lord. Item 48.
Item 48. What is the matter about?
This is transfer matter, my lord.
Transfer method.
That one.
Yes, my lord.
I've
Temporary.
got the instructions. Your
What is that inspection? Why have you done that? Anyway, we'll fix it Friday. No.
Item 52 also, my lord.
We'll have it on Friday, madam. Or next Monday. It's the matter again on 5/1/56/2022. The interim order passed earlier shall continue.
Well, 52, item 52, my lord, interim has to be given to them, my lord. That was fixed today.
What is that matter?
And for Gavura's appointment advertisement published, my lord.
Then?
Last, my lord, but that has not been, my lord, already, my lord, process has not been completed, my lord. That's it for today is fixed for interim order. So, my lord, as time not permitting you, let it be in the next week, my lord.
Now 52.
52.
Yes, Mr. Counsel.
26 family pension matter. Maybe
Have it up to 2 weeks. Yes, Mr.
Item 35 upgraded matter.
His upgraded matters give dates. Huh?
Obliged.
And that his matter 52 interim order is there.
Well, no interim order is given.
Oh, very good.
That was fixed today, my lord. That has been fixed today. But as
We'll have it on 5th.
No agency matter, only the date.
यार जल्दी छुट्टी कर दी
কিমান ডেট ললে? Itu Lisa di
Twenty-two কিমান দিলে? পাঁচ স্টেৰ কাৰণে আছিল হা 5 তাৰিখ বুলি কল 5 তাৰিখ মানে স্টেৰ কাৰণে কৈছে
Well,